We do not interfere with the disciplinary proceeding, but we modify the penalty, punishment, that of compulsory retirement, and we also set aside the finding for recovery of gratuity. But no interference with the disciplinary proceeding, the order of the disciplinary authority, even except to the extent indicated, as well as to the order of the appellant. The court having arrived at this conclusion, it has to be accepted. The decision of the selection committee by being held on 10/10/2014, whereby the private respondents were promoted. The case of the petitioner was rejected in the ground that it was satisfied the criteria prescribed is held to be bad and contrary to the options of the rules. Since it is submitted at the bar, subsequently the petitioner has also been promoted. Therefore, the court refrains from interfering with the selection with the promotion orders of the respondents. However, respondents are directed to hold a new selection review committee meeting to redecide the issue in the terms of the direction of the court, and thereafter restore the position of the security of the petitioner over the private respondents for a time. Any financial benefit that may accrue to the petitioner pursuant to his restoration of his security should also be released without further petition allowed in her case.
I'm okay.
In view of all the discussions above, the writ petition fails. The court is not inclined to accept the contentions of the learned counsel petitioner. Writ petition accordingly stands dismissed. No order is yes.
May I please? One writ petition is posted for motion on 24th of this month. But one IA has been filed that has not been posted. So may I pray the IA to be listed along with the thing.
Writ petition is listed today.
Day of on 24th.
On 24th.
Yes, but IA has not been listed. We have seen the causally solved. So the IA may be
that an IA has been filed in WPC number.
WPC number 5324.
You have mentioned it in the
Yes.
mention memo.
Mention memo.
Day after tomorrow.
Day after tomorrow. Oblige, sir.
But you are beg to mention item number 26. It's a stay vacating matter, Your Lordship. I am for the writ petitioner and the opposite party. The brief has been taken from me, Your Lordship. I have informed the applicants. The matter can be placed after 2 weeks. In the meantime, I'll file the requisite IA.
Who's for the petition?
I'm for the petition. I'm for the
For
petition.
the respondent.
My
You have-
senior, Mr. MJ Quadri.
You have filed the IA on
I have not yet filed the IA. The brief has been taken from me in the meanwhile, Your Lordship. I'll be filing the IA in the meanwhile if the matter can be listed for 2
is
weeks.
that IA listed here 26?
No, Your Lordship, that is not that IA is the stay vacating application. Filed by the applicant, who is the respondent.
That's right.
Yes,
So it's being filed by the respondent.
yes,
and
not me for withdrawal of my name. Your Lordship.
Who's for the petition?
I'm for the petition.
Who's for the respondent?
MJ Quadri. I've taken his consent, Your Lordship.
Learned Counsel Mr. M. Sharma submits that the brief with respect to the petition of the has been taken away. He therefore submits that the matter be listed after the and I think the petitioner will take up the consent of the council the response. So be taken.
Yeah.
Registry is this matter after.
I'm grateful, Your Lordship.
May I please, your Lordship? Lordship, I beg to mention item number 28. Lordship. The matter may be passed over for the day, Lordship.
You are for the petition.
Petitioner, yes.
Item 20 is the request of the that's part. It's the thing.
May I please, your Lordship? My Lord, I beg to mention item number 42, my Lord. Kindly 2 weeks time for filing affidavit in reply, my Lord.
Counsel for the petitioner brings for 2 weeks time. to File reply of the affidavit in opposition filed by the respondent is let us say that here
Interim is there, my Lord.
interim order passed 30. 17th, 18th, sorry, 19th of
Reply.
May I be called? My lord, item number 4, my lord, I beg to mention, my lord. After 1 week, my lord,
item 4 to be
Yes.
treated after request of the
applies, my lord.
May I please your lordship, item number 9, may it fix at 2 p.m.
item 9. Item 9 is
Please.
Lordship, in these matters, the challenges to a notice issued by the CBI and the ED,
there's an
perhaps
interim order.
there is an interim order. Perhaps we may not need to continue with the proceeding, Your Lordship, but I could not complete my instructions. So the matter may be listed in the second week of June, Your Lordship. Perhaps we may withdraw the petition if
Mr. KP Pathak, Learned Counsel. Please hold. 3 weeks time. Complete this instruction. Whether the reception by the person. The further submit the order passed. Permitted to be extended. It's on 24th June.
very
Also, my presence may be recorded. M. Hello for special,
Hello appears for CBI
special,
in all the 3 matters. Yes.
in all,
Lordship P. Ratha on behalf of Mrs. A. Gan, CTC. Okay.
one and
P.
two,
Appears on behalf of
Two only.
in 1 and 2 you are repeating.
And?
In item number 1 and 2, it is
I am for
In-
three.
ED,
3. Who's
Three
appearing
are-
for ED?
ED at the last
I
petition,
ED.
A guy,
A. Gan is
A.
here 20.
Deeply.
I am for 2 and 3. It's second.
Let's forward.
Hello.
Wait, please, Your Lordship, can you pass it on for the time being?
Just issue a notice.
It's for notice.
Brief by the deliberate obedience of the wait. Step on the taken in a week by the court. After it.
List.
pull it up. Pull up.
Peter Love, Madam, the parcel of the writing.
Made vigilant. My lord, this is regarding non-refund of excess airfare related for hospital. This is covered by Annexure 3 at page 65. For a notice maybe.
Here, who's appearing for the respondent?
And standing counsel is there for minority. And even MD Bora is appearing for minority,
Is informer.
minority affairs.
Please inform her.
Yes, Lord.
Wait for a while.
May I please, your lordship. Well, this matter has become infectious.
Mr. M. Ahmed
We have already vacated the quarter. Lordship.
admits that the writ petition has become infructuous. Accordingly, as it were. Item 12.
We have received instruction, Lordship. Petitioner received the payment, Lordship. So his, through their bank account. Only one payment is not been paid because NOC has not received from one. Petitioner.
Which amounts have been received? Which of the amount?
21,07,984 has received by petitioner Soilendra, petitioner number 3, Soilendra Roy, and 13,83,186 was received from by petitioner number 2, and 3,15,822 not cannot be released because NOC not received from one Bhumika Roy, who is the granddaughter of deceased person. And he
21 lakhs released to petitioner 3.
petitioner number 3.
Then. 13
Then
lakhs.
13,83,000 released to petitioner number 2.
And this 3 lakh is to be released for
Eh,
petitioner 1.
One another person is there who is the granddaughter of deceased person, and her father was the NOK of deceased person. Bhumika Roy Sam.
Yeah.
That is the instruction.
Yes, madam, what is it?
Sir, we have got only Jirat value. Compensation is not paid to the petitioners. That is my prayer.
You just heard the learned counsel for the respondent that 2 amounts have been released, 1 amount could not be released because of non-furnishing of the NOC.
As what Jirat value compensation.
Learned counsel for the petitioner for the respondent as Barua
Instruction to the
rupees 21,07,984 as against to petition number 3, rupees 13,83,186 has been paid to. However, 3,58,000 could not be released because of non-furnishing of the NOC by whom?
by one Bhumika Roy. Her father late late Dhiraj Roy, who is the son of deceased person. Deputy Mohan Roy.
Who is the son of deputy,
Deputy Mohan Roy.
not been released to the petitioner one because of non-furnishing of the NOC by her brother.
NOC, daughter-in-law of petitioner number 1. Petitioner number 1 is the wife of the late
by-
Deputy Mohan
by-
Roy.
By layman who is related to by one of the relations of right, not NOC, not released by the daughter-in-law of late Deputy Mohan Roy. So, counsel for the petitioner submits that right to public right, right,
Lordship, the facts in brief of this case is that the petitioners, Lordship, they are tenants of the Kabristan Committee in Adgaon. Lordship, the land of the Kabristan was allotted to the Kabristan by the government. Thereafter, around 30 years ago, the Kabristan Committee and the petitioners came into agreements, tenancy agreements with the petitioners. Thereafter, which is continuing, and they are paying the monthly rent, the due rent regularly, Lordship. Now, Lordship, in the year 2018, when the disposition of the Kabristan Committee changed, they are seeking ways to evict to remove the petitioners, Lordship. Lordship, by filing complaints that they are encroachers. Now, Lordship, in the month of January 2024, they received notices where the petitioners were termed as encroachers. Now, case of the petitioner is that they are not encroachers because they have a tenancy agreement with the committee and they are paying their monthly rents, Lordship. Lordship, on the last occasion when the matter came up, Lordship, instructions were sought from the respondents as to whether the representations have been considered, Lordship, by taking this aspect, Lordship.
One PLPC meeting was held on the
this
basis
PLPC.
Public PLPC Public Land Protection Cell. I have received an instruction
Yes, yes, I've seen it, but
and one meeting is today, will be held today at 11 p.m. And after that meeting,
the counsel for the hearing for the respondent, government advocate, hearing for the respondent, that the meeting of the Public Land Protection Cell LPC, for the Guwahati metropolitan area is underway. And so this was preceded by another meeting held on 11/3/2024. The matter be still after 2 weeks.
yes, please.
I will be able to go the minutes of the meeting stated to be undertaken, stated to be held by the PLPC. Let's be provide.
Lordship, I pray for,
Still after 2 weeks.
Lordship, I pray for date, Lordship.
19th of June. It's not 19th.
Deeply.
Yes, Mr.
May it please your Lordship. Lordship, by this petition, my lord, I'm challenging the notifications, my lord, whereby the time limit prescribed for issuance of order in section 73 has been extended, my lord. This issue is pending before the honorable court, my lord. Similar orders have been passed in page 66, my lord.
Issue is pending before.
This honorable court, my lord, and similar orders have been passed in page 66, my lord. I have annexed, my lord.
Yes,
May pass it, the similar order, because
Mr.
it
KL,
was based on the central government.
Otherwise, there is no, they have challenged notification issued by the central government. But if there is a difference of opinion among different benches, whether matter should be taken by the division bench or single. Some of the court has sent the matter to division bench.
for interpretation of what is force majeure,
Yes, Doctor.
what would be included under force?
Because notification was issued under section 168A. The in our High Court says that main legislation or rules that may be challenged before that will be like before the division bench. But with regard to other lordship, our High Court rule is silent. So the matter coming for Justice Court number 12. After considering all these things, court taken up the matter.
But here notice has been issued.
Yes, ma'am. Otherwise, lordship, we are not objecting to the order.
Right? Yes,
My lord, item number 16 is similar, my lord.
item number
16,
16.
16, my lord. My lord, in item number 15, my lord, I am claiming the order, my lord. 8 page, my lord. 48, my lord, on the ground of limitation, my lord. Lordship, may kindly peruse notification at page 54, my lord. My lord, CL number 1, my lord, from last, my lord. Here, my lord, what happened, my lord, for time limit for issuance of order
Page number, page
54, my lord, annexure F, my lord.
54.
Yes, my lord.
Yes.
My lord, by this notification, my lord, for time limit for issuance of order under section 1710 for the financial year 1718, my lord, was extended up to 31st of December 2023, my lord. Thereafter, no extension was granted, my lord. However, my lord, the order has been passed under section 1710, my lord, on 4th of January, my lord, after the period prescribed, my lord. The order is at page 48, my lord.
Yes.
The date of order is, my lord, 4/1/24, my lord.
4124.
Whereas, my lord, by this notification, the last date was extended up 31st of March, 31st of December 2023, my lord. Therefore, this
When was the notice was issued?
focus was issued on, my lord, 29/9/23, my lord.
23, and the order was passed on 4/1.
4/1, my lord. The time limit for issuance of order was, my lord, 31st December 23, my lord.
Yes. Okay. Appears to be time per
It is
state.
state.
Mr. Chaudhary.
Lordship, but it was based upon the notification of March 23, Lordship, given by the CGST. And secondly, Lordship, in some cases, they have challenged both the notification and the subsequent assessment order.
No, no. Prima facie, it appears to be time. Unless you say that it was subsequently extended by some other notification.
Lordship, that instruction I have to take if the record reveals.
Heard from the party. Vote. Okay. Pursuant to the particular part. Three. Page 54 by the
Respondent number 2, my lord, Central Board of Indirect Taxes, my lord.
Thing to Kelly, the order dated, what is the order, what is your order date?
My lord, it is 4/1/24 at page 48.
4/1/20. 4/1/24 issued by the Office of the Executive Committee, dated
Proceeding may be other than
under 23 of years. By which the petitioner was asked to make payment of its 3,142 as amount outstanding to be payable. 68 years. The order was preceded by of March 2023. So Turner comes to it. The time limit for concluding the assessment was extended up 31st of December
2023.
2023.
My lord,
However, the order part of the whole world, the same is therefore timbered. State PhD, Mr. HDR. The central party also,
Yes, my lord.
Union of India,
GST is also part.
one,
Union of India.
two, three.
So, but DSP, state DSP is shown in
Mukul wo rakha.
Mukul bhai, आप भी आप 2, 3 important.
by the on 19th of June. Till the next week, you are
15 or
yes, ma'am.
Arthik Vedas on behalf of FMLE for respond number 1.
Either
Deeply obliged, my lord.
since the learned here, the way the extra copy is furnished
Ma'am.
within a period of 1 week.
Right. So this is regarding compensation for the, my lord,
Compensation under what?
my lord, under the public law remedy, my lord. Because, my lord, the baby got injury and subsequently infected, and now the baby is, my lord, permanent mental disorder, my lord. And the report says,
What
my
will
lord,
happen to the representation you have preferred?
not yet, no action is taken by the respondent.
Yes, help.
I'm from National Health Mission Europe.
Is the representation pending? Why is it not been?
It's 34, 39.
Yes, madam,
Yes, just now I have received a copy, Lordship.
you get your instructions.
Lordship may issue notice, Lordship.
We're not issuing notice, you get your. The one of the procedure is that petitioner's baby,
Baby, yes.
petitioner baby was delivered in. Where is that FRU Hiranpara?
Biranpara, my lord, my lord, come to page
The-
24.
The newborn baby. But it took it. So it formed right. They're going to deliver. The baby suffered health. Now it diagnosed. Diagnosed to be mentally intellectually impaired. He doesn't have to do it. That this has resulted because of the faults of the ending of the consequent petition for rate of another count if the by the school, which by representation directly 6 inches in the that he is not by the alleged incident like which respect to which the respondent or it is for the detailed report of the detailed report respect of the alleged okay, given opportunity to respond that is for the matter being listed on the first of June in order to facilitate the respondents to obtain the party to take the course of this
My lord.
MS Ikora is for health department.
No.
Is guidance also there?
Yes, I am. Artery.
Notice at this stage not taken.
I am for 2 and 5.
That's what it-
Lord, ma'am, for responding for your lord.
Name please.
ADAS.
They have it.
Responding. Private respondents are there, Lord.
We are not issuing notice at this stage.
Lord.
Now I have to only have to be to ma'am,
To all, to all.
to all. Oblige.
Next, please, Lord. My lord, here I am telling you the order at page 48, my lord. Here, what happened, my lord, the Sokat was issued to the petitioner. The Sokat was issued to the petitioner, my lord. Thereafter, personal hearing was fixed, my lord. On 29/3/23. On that day, my lord, petitioner's representative appeared, my lord, and he submitted his reply. Thereafter, my lord, authority changed, my lord. And this hearing notice was issued, my lord.
Recovery notice
No,
is issued.
No, my lord, order in original, we are challenging the assessment order, my lord. It is the order in original, page 48. Lordship may kindly come to page 50, my lord.
Yes.
Well, there are 2.0, my lord, submission. Here, my lord, here is from it paragraph, it appears, my lord. On 29/3/23, my lord, a hearing was fixed.
So we understand
My-
that your representative was not present.
My lord,
There was some confusion with the date.
Yes, but on one occasion, he was there, my lord, he submitted reply. Thereafter, my lord, the authority changed, my lord. New authority come, my lord. A new authority issued, a-
Pursuant to that, page 54 order is passed.
yes, my lord, 48 order is passed, my lord.
Uh,
My lord,
the effective part of the order is at 54.
my lord.
Now pursuant to that, any recovery notice?
No, my lord, this order has been passed on 28 to 24 recently, my lord, this order has been passed, my lord.
All right, third learned counsel.
Lordship, I have a submission, preliminary submission. This order is appealable order, Lord.
Appealable, all right, but
Lordship, please to see, what my learned friend stated. Lordship, may come to page 50.
Yes.
Paragraph 2. That in order to meet the end of natural justice, the notice was given opportunity of being heard in person on 3 occasions, 1/3/2023, 21/3/2023. Sri Parimal Kalita, the authorized representative, appeared for personal hearing on 29/3/2023. During the personal hearing, he stated that there was no suppression and service tax due were already paid, and therefore they requested to drop the charges. The authorized representative agreed to submit calculation of service tax within 2 days. However, as per the record, there was no such submission. On change of the adjudication authority, wherein the undersigned was assigned the task of adjudication, the SCN, another opportunity of hearing was given on 17/1/2024. But neither did they appear for hearing, nor did they give written submission. As reasonable opportunity has been provided to the noticee to present their case, the SCN is now being taken up for adjudication on the basis of
get the record that by the people.
lobby.
You get the
Lordship.
record, then notice was sent to it.
Yes, Lord.
Third learned counsel. The
One.
Passed.
Number 3, my lord.
State Commission of GST and Federal Excise. ID order dated 28/2023. I state order. The State Commissioner held as under. Reflect the order. Dated. This order was passed. The absence of the order. The petitioner's order was not given an option. By no insurance. And order was passed. On earlier occasion, the operator had appeared, however, the officer concerned was transferred and new incumbent passed the order. Did not hear the operator. Where Mr. Yeah. Yes. Deputy available. It has not been addressed. It has not been paid off. Therefore, the petition will be carried. You're appearing?
Respondent number 1.
Give here for response. Since question of eligibility has been raised, let the matter be discussed after the live time. Please standing down to apprise the court. With regard to the answers raised by the that the order was passed without granting an opportunity of hearing. Authorize that. We are
One,
not issuing notice at this stage.
some protection, my lordship.
So because they have not issued recovery as yet.
But lordship, if some protection may be granted, just in no coercive appeal that, my lord, that may be
But
granted.
no recovery notice is there. They'll have to issue a recovery notice.
After and again, come again, my lord, for some protection.
Let the matter be listed on 31st June. With the next date, courts have action be taken against the petitioner.
Deep to lead,
of lead.
You serve copies.
My
extra
today
copies. Although notices are not issued, however, extra copies be furnished to the respondent council within the course of this week.
May I please?
Yes.
In this case, your lordship, son of the petitioner had expired due to railway accident, your lordship, under the jurisdiction of Sapur GRPS. And accordingly, your lordship, petitioner submitted application to the deputy commissioner of Nagaon for consider her prayer in terms of the notification dated 15/11/2014 issued by the Revenue and Disaster Management Relief and Rehabilitation Grant. And your lordship, the representation of the petitioner is pending till date. Our representation at page 26, your lordship.
Your representation is pending.
Yes, sir.
Yes, who's appearing for railway?
Railway is not party in this.
Railway is not party in this.
Right. What has the state got to do with it?
Yes.
Because your lordship, the railway claim already decided to the in favor of the.
Then why are you asking for another claim? from the state?
Because in addition, your lordship,
Why in addition?
as per the government.
What was the amount granted by the railway?
8 lakh.
How much more are you asking for? Where is the notification?
A notification at page 27, your lordship. Serial number 3, your lordship.
You see the heading in the notification, opening lines of the notification.
Lordship,
You read the notification.
which portion, your lordship? The government of Assam is pleased to revise the quantum of relief in respect of person who were killed, injured due to extremist violence, terrorist violence, act of miscreant, communal violence, ethnic violence, group trash, firing of security force, accident, etc.
These are all related to extremist communal violence.
Lordship, as per serial, your lordship, serial number 3, your lordship, as gracious to the next of king of person killed due to accident in public place or in public careers, other than killed by extremist, terrorist, miscreant, and due to the firing of security forces.
Yes, respondent.
Notice have to go, lordship, otherwise he get the compensation from railway, lordship. And
Who is to decide this compensation?
compensation will decide revenue government, lordship, revenue department.
Who is for
My lord,
review?
after inquiry, deputy commissioner inquired the matter. If he send us the sanction letter, then we'll give the
All right.
money, my
But
lord.
learned counsel for the petitioner is aggrieved by petitioner to the court praying for grant of compensation for the death of a son stated to have been caused stated to have been caused by falling off from a running train and sustaining previous injury. And thereafter, because of the injury sustained, the incident took place on 8/1/2019. Under the support of ARPS. District. The claim of the writ petitioner for compensation under litigation dated 15 November 2014. Counsel for the petitioner submitted that as per serial number 3, indicated the petitioner is facing compensation. So it is also submitted that representation has been filed before the DC Mumbai dated 3/01/2020, requesting for the for compensation. Help. So the representation is stated to have been supported by FIR, final report, post-mortem report, death certificate, and next of kin. So, learned counsel rectified to be 55 by way of speed post. No orders have been sent. And the representation is pending. There are S. Purva and MS Health.
S. Burwa.
And
PR Mohan.
PR Mohan.
A
And-
portable for P9
A-
finance.
Revenue and disaster, sorry. The Deputy Commissioner, my Revenue and Disaster and Finance Department. Submits that the claim of the petitioner needs to be examined, verified by the Deputy Commissioner by calling for appropriate reports.
Yeah.
And if it is found to be genuine, then the proposal is to be forwarded to the
Revenue
Secretary, Commissioner, Revenue and Disaster Management. Thereafter, the appropriate authority in the government will take proper orders for passing a grant of compensation if they will be done. And taking submissions of the government. Voted on the rate petition can be voted state as it is stated under the representation. Filed with the supporting the of the direct C amount to examine the claim of the by calling for reports of calling for detailed reports. Thereafter, the claim for it found to be genuine, the appropriate proposal prepared and sent to the Commissioner, Secretary, grant of compensation to the exercise be completed by the DC in a period of 3 days. In the event the proposal for compensation is sent to the office of Revenue and Disaster. The State Department will consider the claim on the proposal pass appropriate order in further period. Therefore,
One.
it petition according to statute. The petitioner will furnish a certified copy of the order along with the AC.
I'm deeply obliged.
Carry on.
Lordship,
This is an item similar to that of item number 14 and 16 of today's daily list, Lordship. This is related to the extension notification. A similar order is at page 63, Lordship.
Force majority.
Lordship.
All right, Mr. Payal. We keep it together. But,
The order date will be
Date of the order is
22/4/24,
page
Lordship.
number.
Page 69. Mr. Chairman, there is an interim protection, Lordship. The order will not be enforced.
No coercive action.
Oh.
Lordship, can the matter be possible for the time being? Can the matter may be possible for the time being?
Yes.
Lordship, senior is on legs.
Okay.
Ma'am, little bit. The petitioner has been possessing a plot of land measuring 9 lakhs, covered by dark number, Dulia, revenue village, Dulia Pyramid. Okay. On 20/1/1999, the subdivision land advisory committee of Guwahati Law to approve for recommendation for allotment of order in respect of the petitioner's name. Page 23, serial number 27. With a condition that allotment of this plot of land be done after registration of deed reserve company. And the respondent number 8 also issued no objection certificate, Lordship. Page 28-29. The Honorable Governor of Assam also pleased to agree with the deed reserve proposal.
Where is that?
Annexa is page 29. Oh, sorry, 49, Lordship.
Page
49.
Yes. Then
Till the respondent not settlement of plot of land.
third, settlement of that. Okay, fine. Let us write that. Fine. It is Dia Mera Bhai. Dia Mera Bhai. Paper of the document. Okay. Okay. Who the- it's okay. Given approval by the governor of Assam. Same communicated by application dated 19th of March 2014
Yes, Lord.
by party. Are you in possession?
Yes, Lordship.
You're in possession.
Yes.
However, the same. Uh, Yes. Sir. Purva,
Yes, Lordship, regarding the Annexa L, 56 page number. In this, regarding this Annexa, I have to take instruction. Notice have to go.
Purva, all responded.
No, Lordship.
I'm
5, 6, 7, 8.
Mr. P.R. Monroe appears to responded one.
two and three, my lord.
Mr. R. for 3. Mr. Purva for 4, 5, 6, 7,
8.
8. So the way.
And-
party. Then matter be listed after.
Like,
Please also. Lordship, this petition assails form number ASMP 10 issued by GST authorities which is related to scrutiny proceedings. But before issuance of that form, Lordship, for the same year, the audit proceedings were already completed in 2023. As per statutory scheme, Lordship, section 61 talks about scrutiny proceedings, and it says that if I don't agree to the findings, the authorities may proceed with either section 65, which is audit, or section 73 for adjudication, or section 74 if there is any suppression. In this case, Lordship, after 65, which is audit, they have availed 61, which is scrutiny, which is not the statutory scheme, Lordship. So I pray that the proceedings under section 61 may kept in abeyance until disposal of this petition, Lordship.
Where is the notice?
Lordship, the notice is at page 27.
The KL, what
Approximately pleased to see. The notice was issued under section 16(4). And the allegation is that they have availed the ITC beyond past time limit. And earlier was Lordship, in my humble submission. This was matter of scrutiny. And approximately pleased to see page 27.
Yes.
The power line industry is having principle of so and so.
This is issued under 64.
16(4).
Lordship, if
16(4).
your Lordship peruses GST rules, Lordship, I am showing the notice. Rule 99, Lordship.
Yes. Tell us.
Lordship, Rule 99 makes it clear that form number ASMT 10, it is issued under Rule 99, which gets power from section 61, Lordship. If I may please read. Where any return furnished by a registered person is selected for scrutiny, the proper officer shall scrutinize the same in accordance with the provisions of section 61, with reference to the information available with him, and in case of any discrepancy, he shall issue notice to the said person in form GST ASMT 10. So, Lordship, this form has been issued under section 61, read with Rule 99, which gets clear upon a perusal of Rule 99, Lordship. Now, Lordship, if peruses section 61, (61)(1) says, Lordship, the proper officer may scrutinize the return and related particulars furnished by the registered person to verify the correctness of the return and inform him of the discrepancies noticed. Subsection 3, Lordship, last part, last 3 lines. The proper officer may initiate appropriate action, including those under section 65, 66, 67, 73, or 74. So, Lordship, 61 precedes 65. It cannot be done after 65. Now, Lordship will peruse the audit findings which they have completed, which is at page 20.
See 65.
Lordship. (65), Lordship, audit by tax authorities. The commissioner or any officer authorized by him by way of general or specific order may undertake audit of any registered person for such period at such frequency and in such manner as may be prescribed. Lordship, what can be done after audit? Subsection 7 speaks about it. Where the audit conducted under subsection 1 results in detection of tax not paid or short paid or erroneously refunded or input tax credit wrongly availed, the proper officer may initiate action under section 73 or section 74. So now, Lordship, in this section 65 proceedings, when it was conducted, they came up with some demand that so and so is payable. I agreed to it. I paid it. Now, all of a sudden, they started scrutiny proceedings after conducting the audit proceedings, and now they come up with a fresh demand. So that is against the statutory scheme, Lordship. Lordship will peruse page 20 of my petition, Lordship, which is the audit findings.
Yes.
Page 20, it reads, the heading is Final Audit Report, Lordship. Page 21, the first point is wrongful availment and utilization of input tax credit amounting to so and so in violation of section 16. The earlier demand was also in violation of 16, and now in scrutiny also they say 16, but a new amount. During the course of audit and on scrutiny of books of accounts for the period from July 17 to March 20, the ASMT 10 is for 1920, Lordship. It has been observed that the taxpayer, in violation of provisions of section 16 and 39 of Act, read with Rule 61, has availed excess input tax credit to the tune of so and so. Now, Lordship, in page 22, below the table.
To express why the scrutiny can be carried out.
No, but Lordship, the scheme is, if I don't agree to the scrutiny proceeding, they might conduct an audit in my premises. When they have extensively conducted the audit and they have come up with the findings to which I have agreed, as mentioned in page 22 of my petition, Lordship, the paragraph says, the taxpayer has accepted the audit finding and voluntarily reversed and paid the excess ITC and also paid the interest amount. Subsequently, there was again a finding on page 23 regarding interest, which also I agreed and I paid, Lordship. So after 65, in sync
That
with the.
express why that you are trying. Discernible.
No, but Lordship, settled things cannot be unsettled. And if the statute says that the thing has to be done in a particular manner, they have to do it in that particular manner.
But that does not affect the bar.
No, but after 65, they either go to 73 or 74. That the statute says, Lordship. But after 65, they are going to 61.
All right, Mr. K, I'll get your instruction.
No.
Third learned account. Notice dated 23 issued by the ministry authority. Under section 64.
61. 61, Lordship, scrutiny. Alleging violation of 16.4.
Submit aggrieved by the notice dated alleging violation of section 16. Council submit earlier a detailed audit was conducted by the. Where is the audit?
It is at page 20, Lordship. Date is 27/4/23.
What was the finding?
The findings is the demand was raised, which was accepted by the petitioner and paid.
Demand was made pursuant to the order. That is the state of the state. Now, section
Lordship, in a similar case which came up after conduct of audit proceedings, it is pending before this court, Lordship. If I may furnish a copy of the order.
submits that as per the provisions of the Act, once detailed audit is conducted, and the demand has been raised and the amount recovered from the issuance of the units is opposed to the scheme of the Act. Therefore, that you order you permit the independent proceedings contemplated against the petition. And the respondent will restrain proceeding against the in pursuance of it. He has also referred the order dated 11/2023 passed with the of 2020. Notice was not issued there.
The lordship, notice was issued in under section 73.
No, in this writ petition. it will be.
Yes, in this 73 notice was issued, lordship. It was also status quo was ordered, lordship.
But notice in the matter was not issued. Where Mr. KL learned that department authority rights to proceed with the proceedings contemplated by the impute notice dated 24. So there is no much bar under the Act. That department has to proceed after the audit. Treated as it the matter will require exam. Till the next returnable date, no board's back. Pursuant to
If the proceedings can be kept in abeyance or status quo as in earlier order, lordship.
no coercive step.
Lordship, they will proceed with the proceedings.
Lordship, the
So which
notice
will
is,
duplicacy of proceedings.
notice was issued in February 2024, Lordship.
No proceeding is contemplated under the proceeding
Lordship, highly obliged, lordship.
matter be listed. Right. Not it be fixed by the
Obliged, lordship.
May I please the lordship? Should that the petitioner's land measuring 18 lessa has been acquired under the provision of National Highways Act 1956. According to my lord, the amount of rupees was awarded to the petitioner as compensation, which is page 31, annexure 8.
Yes.
Last part, left hand side, amount 1,99,751.12, and it is divided by 2%. The petitioner and the co-partner. And another is page, my lord, page 37.
Yes.
It is also 29,20,333 divided by 2. My lord, on being agreed with this award, the petitioner lodged a representation to the appropriate authority.
This compensation you are taking for what? Acquisition?
My lord,
For what purpose?
acquisition of land for construction of national highway.
Who is the requiring?
Lordship,
Highway authority.
Lordship, as per National Highways Act 3G5, Lordship, if he not agree with the award amount, Lordship, he may file application, Lordship. That already filed annexure 15 page.
Yeah, that is already filed. Annexure 15 page
And that
52.
will decide by the appointed arbitrator, my lord. And arbitrator has already been appointed by the government of India.
Page number?
Page number 52. Is pending since near about 6 months.
6 months.
Yes, my lord.
Now he says that arbitrator has.
Yes, Lordship, Gazette notification has been published, my lord.
Where is the Gazette notice? Show it to him.
Appointed arbitrator.
Decided by the
Yes, Lord.
arbitrator.
Let the matter
Yes,
be decided by the arbitrator, my lord. Lordship, similar order, Lordship.
Yes, sir, within a
Order
specific
already
dates,
passed.
my lord. In a specific period.
Why give an order? Because now it is there, they decided. Why do you want an order from the court?
My lord, it is so since long it is
But
it has been
since
pending.
long it has not been appointed. Now they have been appointed.
Appointed, Lordship.
Appointed already 2 months ago.
Where is that order?
Gazette notification.
What are you showing?
When appointed?
That is, Lordship, similar cases, Lordship, this honorable court has passed an order to, with the direction to decide the case within a specific period as per arbitration and conciliation act, my lord. Paragraph 5 from 5, my lord.
Where is the person?
Lordship, that is first page, Lordship, Special Secretary to Government of Assam, my lord. First page.
Okay. Disposing it of partner of the party. Yes.
Item 25.
Right. There is a case, my lord, 17.5 lakhs of land was allotted by the SDLSC, my lord, in favor of the petitioner, my lord, in the year 2015. Thereafter, my lord, page 42, the premium value was fixed at rupees 35,000, my lord. Thereafter, my lord, the deputy commissioner in the year 2017 forwarded a letter to the government for allotment, my lord, page 47. But the government of Assam has not taken any action, my lord. Accordingly, my lord, the petitioner approached this honorable court, my lord, by filing writ petition, my lord, and during this pendency of the writ petition, my lord, the page 48, the approval was accorded, but stating that, my lord, and directed to pay the premium.
Tendency of which writ petition? This,
Yes.
This.
Yes. No, my lord, earlier writ petition. Page 48, my lord.
Yes.
The government of in inviting a reference to the subject cited above, I am directed to convey that the governor of Assam is pleased to accord approval for settlement of land measuring 17.50 lessa covered by the number so and so so and so. Then, my lord, subject to realization of settlement premium as per GOP notification 21/8/2023. Although, my lord, the allotment was granted in the year 2015 and the premium fixed in the year 2016, my lord, but subsequently this letter, my lord, directed to pay premium as per notification 23, my lord. Accordingly, my lord, the petitioner submitted an representation, my lord, page 53. My lord, with a prayer to accept the premium in terms of the value fixed by the department in the year 2016, my lord. Last paragraph, my lord. It is therefore prayed before your honor kindly to allow me to deposit the assessed amount of rupees 35,000 through the procedure followed by your office as early as possible. So, accordingly, my lord, the circle officer, my lord.
So this 35,000.
35,000, yes.
As per the notification of 2023.
No, my lord, as per the zonal value fixed in the year 2016, my lord. My lord, the zonal value fixed in page 42.
The Assam has accorded approval subject to realization as per notification 23.
But the allotment was given in the year 2015, my lord. My lord, it is the lack of the respondents to accord approval, my lord. Although the allotment granted 2015, the approval was granted in the year 2024 under the interference by this honorable court, my lord. And my lord directed to pay premium in terms of 2023 notification, my lord. All the things are conducted under the old zonal value, my lord. And the value already fixed, my lord, page 42. Page 42, my lord. Page 42, second paragraph, my lord. As per Latmandal report, the value of the aforesaid land is assessed at rupees 2 lakhs only per bigha. Hence, the valuation of 17.5 lakhs are stand at rupees 35.
Now you put this notification to challenge.
My lord.
You not put this notification to challenge.
My lord, because this 2023 notification not applicable to us, my lord, because the allotment was granted under the old notification, my lord. And my lord, the allotment granted under the 1989 policy, my lord, land policy. And the new valuation fixed, my lord, under 2019 land policy, my lord. I am
89 policy not in force, my lord.
Yes.
Now it is 19, land policy 19. Lecture 1548 is clear, my lord.
23.
19,
Land policy.
2019. Land policy 2019.
Then
Then, my lord, annexure 1548 is clear, my lord. The settlement is realization to subject premium of as per government notification so and so dated 21/8/23, my lord. At the time of hearing, they did not raise any objection, my lord, the earlier repetition, my lord. That is
where is the earlier?
judgment 51, page number 51, my lord.
It's been closed.
My lord, because my lord, earlier writ petition was closed, my lord, subject to this order,
At
my
the
lord.
time of hearing,
16
they
to
did not raise any
16
objection,
to
my lord.
2024, my lord. Because this is a fresh cause of action, my lord. That is why earlier writ petition, how it can be decided, my lord. Earlier this writ petition was filed only for approval, my lord. And during pendency, my lord, the
Or we are asking you, have you put 16 to, have you challenged 16 to?
my lord, I have challenged only this condition, my lord. Yes.
You have not challenged.
My lord, I have
challenged 16 to.
16 to, my lord. Kindly come to prayer, my lord.
Come to your prayer here.
Yes, my lord. Causing the improved direction for realization of settlement premium as per notification so and so by letter dated 16 to 2024. my lord. I have challenged, my lord, this condition. I am not challenged entire letter dated 16 to, my lord, because
Heard counsel. We are control and here's responded. And then grew up on responded to it. He responded. The way Brahma after return.
obliged.
May I please? May I please?
So,
This is
actually, the learned advocate general will appear in this matter period and matter will be fixed at 2 o'clock.
a fresh matter.
What is this matter about?
Actually, Madam, this is the matter which is a challenge by one of the board areas of Kamakya, the Kamakya corridor. Because Madam, what is envisaged in this entire process is that it's a 404 crore project tender which has been awarded, which will entail Millards digging at least 300-400 feet. So the main apprehension of the petitioner, who is a practicing board area, Millard, and a panda there, is that the holy springs, underground springs, and the sacred water will be disrupted. And
There is
there's
actually environment bench.
it will no, Millard, it is actually a mix of environment and Article 25 and 26 also there. Millard, because it's my right to practice my, because today, as your Lordship is aware, Millard, I don't need to explain to anyone from Assam that when we go to pray there, it is the darshan is actually contact with the water, and then we're not sticking it on our head or having it or whatever in whatever. The complex Millard will today have 5 levels. 5 levels of digging on the hillside will mean retention walls of 200-300 feet. And Millard's right, starting from as we enter Millard's, as your Lordship may be aware, from Millard's Chinnamasta onwards, it will be flattened. The Tara Mandil will be not at an elevation. It will be a flat. So there will be 5 levels there. Then Millard's, I think it will also touch the neighboring the Bhairavi temple on the left, the bottom. Then next to Dhumavati. From Millard's, today there is no hydrological study which has been undertaken of this entire process. And surprisingly enough, what we found was that AISA has also not declared it as a protected monument. What is protected is that rock inscription, as your Lordship sees when you cross Kamakya on the right, Dorgila, that was 1732. This entire temple complex has been built over 1500 years, over three stages. It is not an ASI monument. The gate is protected, the inscription is protected. So the ASI has not been consulted. It is like a normal PWD project. Like the next normal the state guest house being built, a PWD floats a tender, LNT respondent number 10 is granted that for 404. No hydrological study as to how the sacred spring. And I mean, I myself remember about a year or 2 years ago, when this Saubhagya Kund, where we go initially to do that, when there had been drained to clean it up, even the main Kamakhya Peeth did not have water at that point. It is so delicate, that ecosystem. And it is fundamental and intrinsic to our faith, particularly as a practicing pujari who I am, and as a devotee, of course, I personally am, and as the petitioner who I represent.
Has a public interest.
More than a public interest, today it also affects more. Of course, there's a public interest, but today the litigant before your lordship, petitioner, is a practicing Baudewari who in the main temple.
No, his apprehension that his right to practice,
yes, is also
will be gravely affected by the proposed construction.
And they say, they say that there will be demolition, excavation, reconstruction. So excavation.
I think better to take it up with environment. There is an environment.
That's a division bench. Today I lose a right of appeal.
No.
Today, today it is a division bench. Today, as a petitioner, because today my locus, I am informed, there is also a PIL which is pending, which I will see on this issue, but that does not challenge the work order, which is what we are primarily concerned. Today, nobody can dispute that some beautification is required, but it cannot be at the cost of a fundamental right to practice or upsetting the essentials of worship over there. Single bench, because if I go before a division bench, then I lose a right of appeal. I am today directly affected, not as
no, it's not about
in my personal capacity as a.
It's about the propriety, because the benches are constituted like that. We'll hear you. Let the Advocate General come. We'll hear you.
Hey.
What time is it?
2 o'clock if possible.
I'm good.
We will hear you, but
I understand where your lordship is coming
I
from.
feel that perhaps it may require may be required to be addressed before
No, as long.
unless you state your argument that no, it is essentially a right of practice.
It is essentially a right to practice because under 25 and 26, I will show there is law on that subject. That what is the essential right to practice or worship? Essential right to worship is actually defined in the negative. That if it were not there, would it take away the fundamental worship to that deity? And today, the fundamental worship to the Kamakya.
I'm certain that is raised important question.
Yes, madam.
Of fact that preservation, ecology.
Because
then you are asking for interference with the order, the what is that? The stay order regarding the work order has been issued.
The work order has been issued. Yes.
Work order.
And without undertaking any hydrological study, ASI is not being consulted. It is like building the guest house next door. They are just doing it. So that is the difficulty. If that all those safeguards have been taken, we wouldn't have been concerned. But today, the repercussions, the ramifications are irreversible if the moment of process happens. And we have the next color photograph where they have shown at 95, 96, it is there. The Lordship sees it. 96 onwards, there are color photographs. Because today it is also not in the public domain, no consultation, it's only social media post. This is your Lordship will see on the left hand side. Your Lordship has page 96.
Yes.
This is the existing on the left hand side. What is circle? Ma Chinnamasta, Dakshina Kali, Ma Tara, and the Ma Kamakhya temple. On the right hand side, your Lordship will see. And this is what I want to point out, your Lordship. The Ma Kedareshwar, this is Ma Kamakhya Mandir is here. Chinnamasta Mandir and all of that, it has a flat elevation all over. And at Page 100, your lordships may see, and which becomes very clear because I think Matara Mandir Malad, as we go up, is page 100, your lordships have Malad. So that becomes very clear from there. The second Malad, set of photographs, area in front of Matara Mandir, elevation flattened. So the entire elevation will be flattened.
So, but how does it essentially affect the right of way?
Because so that's the fundamental fact. It interrupts because it is not going to be a mere dressing up or changing of tiles. To build on the hillside, they will require retention walls of 200, 300 feet excavation. Today, as your lordships go down, this is a fundamental fact which has been missed out. No hydrological study has been undertaken. Today, if you are going to dig all around, that entire flow is going to be disrupted. That is fundamental to my practice of my faith.
All right. Continue it.
So, real.
Time being, I will take.
And again,
Item 7 and 8.
yes.
Thank you, your lordship. Lordship, here, this application is paid for against the impugned notice of the respondents, whereby lordship, I was asked to hand over my land. The land in question is a commercial land, lordship, and due to the intersection of the this trumpet in the intersection bisected the commercial plot of land, whereby petitioner has suffered use loss, lordship. So, lordship, at this stage, we pray for lordship fair compensation in terms of 23(1) of the Compensation Act 2013, lordship.
Yeah. Who was the respondent here? Instructions.
I am for 2 and 3, lordship. Notice have to go, lordship.
Notice not issued.
No, lordship.
Yes, Mr. Nayak.
Lordship, here, the Lordship may kindly see the prayer, Lord.
Prayer.
It appears, Lordship, what he is apprehending, that is without any information, Lordship. Prayer number A, any other appropriate reader should not be issued, directing the concerned respondents to furnish the actual information.
Which WPC you are referring? There are two.
Lordship. Lordship will dispose of this matter, directing the operator to either furnish her whatever instructions he requires, Lordship. If she is still aggrieved, Lord, then she may file another petition.
There are two writ petition. The earlier set of writ petition for lordship
No, her prayer is for
compensation, lordship.
compensation.
There are
You're
two set of
referring to which
writ
writ?
petition.
2971.
2971.
What is your prayer here?
No, 2971, it was
Page
earlier
11.
point of time regarding to, we sought
Yeah.
for stay in that,
Actual information. Have you received it now? You have received it.
that by the impugned notice, lordship, they are acquiring now. So that is why the second
So this
application has
earlier
been,
petition has become infractuous,
yes, lordship.
right? WPC 2971 submitted by the council.
Yeah, that's an elder.
As infractuous. Now in this writ petition,
This compensation.
compensation. You need to notice here.
Yes.
Economic complaint. I don't know.
This WPC
First one.
76.
Seven.
Item number 7 is also there.
Their silence is not a party.
Yes.
In the second reading.
In
first
item,
as to the-
item 7, I'm not,
You are not.
I'm not there in item number.
Item number 8 to Mr. Nayak.
Lord.
As finance. Item 8 is disposal. This which has. Now item 7 will issue notice. Who appears for disaster management? PR model. Appears for disaster management.
P. Mohanta.
P. Mohanta was
When the advocate setting up the way now. It's after
First.
Meet video lawsuit. My lord, without serving us copy, this matter has been filed.
Serve copies. Serve copies. You serve, you take it up at 2 p.m. Do you have copies?
Yes, I have gone through the second copy already.
Ah.
Take up the matter.
Yes, then.
First, may take up this matter, but I have informed without serving us copy, they have filed the cases.
Oh, he is praying for
Representation disposal, my lord.
in
But
terms
lordship,
of this order.
the earlier order of this honorable court,
Where is that order?
first page, my lord.
44, lordship, 45. And relevant part.
Relevant is page 65, my lord.
65, my lord.
65, 66.
Similar order maybe.
Have you gone through this order?
No. Directed the respondent number 2 to dispose of the representation. Lordship, 2, I am not appearing. I am appearing only for 5 years. Minor case.
Right, it's for respondent number.
5, my lord.
That's for 5.
One Central Government Council. My senior may appear.
Mr. T. Gogoi for
One or two, one or two.
respondent number 1.
One and two also.
Then what about 2?
Two, my senior.
I
Going for 1 and 3. 3 also. 3, 4.
I am for 2, lordship. Central House Committee, Union of India.
So, but unless you represent, how do we dispose it of? The central house committee, state house.
Chairman is a party, we are not representing the chairman, my lord. Is elected.
Then lordship will notice me, lordship.
No, we are disposing it off. We are recording your names for 1, 2, 3, and 5.
Lordship.
3 and 5, lordship, I cannot, lordship.
Right?
Five.
3 and 5, my.
Executive officer must be
Lordship,
government
3 I can appear. This lordship directed. 3 I can appear, but 4 I can't appear.
Okay, 1 and 3 and 5.
5.
Four. Now, to the part. Sorry. Just by this four.
No protection.
Lordship may kindly direct the respondent number 2. He is the authority regarding that. The Chief Executive Officer, Central House Committee, India.
Lordship,
Yeah.
lordship, I have pay a copy from the petitioner because a copy has to send to the. Copy has to be-
Same prayer from me also, my lord.
I'll
Mr.
Item 21.
Yes.
My lord, when a plot of land is acquired for public purposes, we don't object. But here, my lord, the land of the petitioner is his private land, patta land, and we have filed a representation before the railway authorities against the proposed extension of the platform of that area. Your lordship will find that at page 48, and the prayer that we made before the authorities was at page 49.
Yes.
48 is the representation file, my lord.
which was received on 10th of May. And 49 is the, your lordship, therefore I kindly request your good self. They can do, but they have to follow the due process of law and
You are agreed by what?
by the proposed extension, they are threatening that they will occupy my Nyadipatta land.
That is 1 Kata 11 letter.
Yes, madam.
They have not issued notices.
No, no.
Nothing is there, mere apprehension, lordship. And if we act, lordship, then as per
Now
the
it's-
procedure of the law.
it's-
You look into the grievances raised in the representation.
That part I have not, otherwise petitioner's petition is premature one. No action was taken by the authority.
He will take a look into the grievances of the petitioner. And
Otherwise,
till such time, no coercive
if we-
action will
if we
taken
take
without
a-
following the due process of law.
That,
Whatever is there,
lordship.
you redress, you look into the grievances. Exercise.
Regarding that part, I am not, otherwise, lordship, it's a premature matter, we have not taken any action. If action will be taken in the lordship railway land, then it will be lordship public premises, unauthorized occupant act. lordship.
They have only to verify the facts.
Otherwise, lordship, honorable appears to time and again reiterated, lordship, this kind of petition is not maintainable. lordship. In 2019 also, honorable Supreme Court says, lordship.
Only till such inquiry by the authorities, they will not take any coercive action. Your lordship will fix the time frame. I have no objection.
Third learned counsel. Petitioner is briefed by the petitioner expresses apprehension that is near the Patal land covered comprising of 1 Kota 11 letters of the back number whole slash 4477 covered by periodic Pata 1 whole slash 495 situated in Margarita town behind the Margarita club. Yes, that's something. The Margarita yeah. Maybe it will be required by the railway authority or expected. The Margarita railway station. We submitted that. Is land and the building of this particular plot of land does not is not railway land. It's submitted that the last month of the central the where is the revenue, where is the survey carried out?
My lord.
Carried out the survey and it was found that the particular plot of land is not on the railway. Therefore, the railway authority, if they want to acquire the land, then the same has to be acquired by the process of law. So this conflict against because as well as to the railway authority. It was received by the division of the railway manager west and a railway engineer. Who is the appropriate authority in the railway side?
Railway lordship, they have preferred a representation before lordship.
Railway authority.
Railway authority, they have.
Divisional engineer, I think,
Page
Northern Frontier Railway.
page 48, they have.
No, I know they have prepared. Right?
Possible.
You will be the.
Then my lord, respond number 4.
Divisional engineer. Respondent number 4.
He therefore submit that therefore he expresses serious apprehension that without following the railway authority.
Respondent number 4.
Undertake construction of the land belonging to him, considering the same railway. He expressing such apprehension, the missionary council representing CGC. CGC. representing the Union of India and the Railway Authority, as well as Mr. N. Goswami appearing for the circle of
Respondent of 5.
Respondent 5. Submit.
21.
The petition is filed entirely on the basis of an apprehension which is, as on date, such steps have been taken by the Railway Authority to erect, construct the railway platform
In the petitioner's language.
on the writ petitioner's back. Taking the submissions made by the respective council, so the view that since the representation of the Railway Authority are pending and the apprehension expressed by the petitioner is towards the action, proposed action to be undertaken by the Railway Authority, is being treated proper dispose of the petition state directing the divisional railway manager as for the board to look into the grievances raised by the petitioner by the board and then pass appropriate orders matter.
Their representation page 48 lordship request for protection of property right and compensation. Then my lord may page 49, my lord may kindly peruse lordship. 1, 2, 3 and 4 lordship.
If they need it for
The Railway Authority, the look into the grievances and pass appropriate orders in time frame. So, let the representation be disposed of in the date of 30 days, the date of that is passed by the responsible board, copy thereof. Disposed of by the petition accordingly set disposed of.
But till the disposal, they will not take any courses. 30 days. They will not take after your. Also, but if it is specific, my lord, then it's better.
If they take, then you come before us. How can you take courtship with what?
My lord?
What courtship step?
Means without serving any notice, they will not demolish my house where I'm staying at the moment.
Obviously, because
Now it is 80 meters from my house. That's the fear.
no. Have they taken any steps for construction?
Already construction is going on. It has reached 80 meters from my house.
Since the advance or the apprehension expressed by the writ petition is that the construction which is undertaken by the railway authorities of the railway platform has reached is within the vicinity of the land and building of the writ petitioner where the petitioner resides. The railway authorities will not proceed to extend or attempt to construct the land of the writ petition.
Without following the due process.
Following due procedure and the disposal of the
Obliged.
representation.
Obliged.
Disposal of.
We are obliged.
Lordship, I need to file objection in this regard, Lordship, at least 2 weeks time, Lordship.
My lord, you are the general members of the.
All right, heard counsel for the parties issued notice. Returnable reading. The Mr.
P. Bordwell, Lordship.
P. Bordwell appearing for
Writ petitioner, Lord.
writ petitioner submits that you'd like to file objection.
Lordship.
MS MD Bora appears for the cooperative Islam.
Respondent number 2, 3, 4, 6, 7, and 8, my lord.
2, 3, 4, 6, 7, 8.
The Corporation Department.
Ms. S. Bora for respondent 5.
5.
Let the opposite party file necessary application. Necessary objections, if so advised.
Lordship, I am not filing any objection.
Let extra copies of the IA be served on the party council within the course of this.
My lord, only prayer is that date may be because, my lord,
Matter will be listed again on 21st June.
Deeply obliged, my lord.
21st June.
Interim order may be continued.
entire function is, my lord, paralyzed. It is a Samavai society, my stated para 5, my lord, what kind of our
14th of June. 14th of
My lord.
interim order passed earlier, if any, will continue.
we could not
Oblige.
That is in the report.
Oblige.
Deeply obliged.
29, 30.
May it please the Lord. Last order says the Mala central government was to furnish some particular details about our houses and properties over the prohibited zone of the archaeological department.
Sorry?
Malada, the central government was to furnish some more particulars to an affidavit. It was the last order.
What is your demand?
We must, Malad, they have issued a show cause notice saying that to evict from our places, we have a patta land, tea gardens and others are there. Show cause notices are issued
What
saying
centrally protected monuments are available?
monuments, Malad.
But you are not the custodian of that monument.
No, we are not custodian. We have our houses. We have
On
our
the land on where the monuments are there.
Malad, within the 100 meters.
So what instructions are required?
My lord, I am appearing in item number 30, my lord. My lord, some as per the last order, we have received some instruction from the department. We want to put it on record by filing an appeal.
MS Mr. A.K. Totro appearing in WPC 6283.
2 weeks. We have already.
You are appearing in which matter?
Both 29 and 30. Huh? Both 29 and 30.
29 in 29 H. Gupta.
H. Gupta.
And I am in
Mr. A.K. Totro learned CGC.
CGC.
Appears in WPC 628 of 2023. Submits that is received some instructions we'd like to file an affidavit to bring it on report. He prays for how much time?
3 weeks time.
3 weeks time. Anyone else appearing here? Mr.
I'm appealing
Gupta?
for the state respondent, 5-6.
Mr. DJ Taluka, Senior Counsel, appears on behalf of
5, 6 and 7.
respondents 5, 6, and 7.
Right.
Mr. H. Gupta, and CPC appearing in WPT 5147 of 2022. Make similar prayer. Praying for time to file necessary affidavit. It will be listed after 3 weeks. Interim order passed earlier will continue. Here, Roy, sorry, yes, for the day.
Item number 31.
My lord, the bank need to file an affidavit in this case, my lord. Lookout notice has been issued against the petitioner. And recently, my lord, the courts have held that PSU cannot issue lookout notices. Be that as it may, my lord, this will need some length of some hearing, my lord.
My lord, I am for the bank, and in this case, CBI and AD investigation is going on. So I need 4 weeks time to file a affidavit in.
My lord, 2022 matter, my lord. Only my prayer is that, my lord, because of this lookout, I'll satisfy your lordship, my lord. His movement has been put to an halt, my lord.
He has diverted more than 200 crores money.
Let him file affidavit, my
Yes,
lord.
I will file it.
My only prayer is that 2 weeks a fixed date time, my lord. It was 2022, 2 years have elapsed, my lord.
Do you think he'll be able to file an affidavit to 4 volumes? in
My
two
lord,
weeks?
these are annexures. The main petition is only, my lord,
Are you suggesting the annexures are not relevant?
my lord, just to bring certain things on record, at times we'll have to annex certain documents,
very
probably which are not relevant, but so that we save ourselves from suppression of facts. But probably for adjudication of this is one-liner case.
4 weeks time may be given.
4
because
weeks.
of,
Wait for 4 weeks.
My lord, in the 3rd week of June, some fixed date, my lord, because after a long struggle, somehow it could listed, my lord.
Why so much of struggle?
My lord, somehow it was not listed. Then we made a mention. There are 2 read petitions. Today, one got listed before your lordship and another got listed before another coordinate bench. There also, we made a submission that these are same. Then an order was passed that to take this matter along with this matter.
in that case, they have not supplied the annexures.
They must have added it here.
All you.
I have to verify. In
Yes,
that
I'd
case,
learn-
they have not.
Learned counsel. The parties. Learned counsel a hearing for the bank, wait for 4 weeks time. File counter affidavit. This was learned counsel for the petition. Submits that matter be listed in the 3rd week of June. Nothing states as who has issued the lookout bank?
Bank, State Bank.
As the bank has issued a lookout notice. The movement of the writ petitioner is restrained and therefore certain orders are called for. So that you're appearing for?
For 1 and 2, your lord.
So that appears for 1 and 2, the union.
Union of Indian Bureau of Immigration.
He was going to one of his relations' marriage in Vietnam. For the immigration, he was pulled back.
Now you deposit the passport before the local police station.
All of those things, because once a lookout notice is there, even if I have a passport, I cannot use it.
No, but you don't, why use it during the pendency of the court proceeding? You deposit it before the local police station.
My lord, as such, lookout notice is under challenge, my lord, if the lookout notice goes, my lord, because no such order is there, my lord.
Let the matter be listed on
14th of June, my lord.
No, not 14. Now he's praying for 3 weeks time, asking for 14.
14 would be 3 weeks, I guess.
21st June.
Much okay.
Much okay.
It is submitted that there is another writ petition being, what is the number? Other number?
7499.
WPC 7499 of 2022.
My lord,
Submitted.
my lord, any date barring 21st. Any date barring 21st, maybe
No,
18,
24th.
24th.
The writ petition be listed along with WPC so as to.
I'm with you.
Much.
Item 32.
On the last occasion, there was no appearance on the side of the petitioner.
And
And
appears for the writ petitioner, Mr. Rai Boda for the Department of Forests. Understand past over. Be listed next week. Who's for the state? The writ petition by the state.
State lordship.
Why?
They have prayed for direction to the respondent number 6 and 7 for making payment. It is arising out of a land acquisition case. And
None appears for the writ petitioner. Mr. R.P. Kakuti, senior counsel, appears for IT.
Lordship.
And
SD Purka.
Mr. Purkaitu appears for
1, 2, and 3.
respondent 1. Matter be listed next week. Yes.
Please, your lordship. As regards renewal, before this honorable court, I have no case because the similarly situated petitioner had come before this court and the REIT appeal has did not find favor. However, my lord, an SLP is pending in that case. What I am praying for is extension in terms of the railway board's mandate, lordship.
No,
The
who-
railway board being the
Who are you? You're a contractor,
I am a
caterer.
caterer running catering stalls in the 3 stalls I have at
Right.
Guwahati railway station and 2 at Kamakya railway station.
On the platform. On the platform,
Yes, Lord.
railway platform.
Yes, Lord.
Then?
My lord, on the one, I had filed this writ petition on being aggrieved by the order, impugned order, which had directed me to vacate the stalls, which your lordship will find at page 23. And on moving this court, on the first date, that means on 27/3/2023, interim order was passed, lordship. And I am protected by that order.
Yes. So what do you say, railways?
Meanwhile, my lord,
Sorry.
he has also filed writ petitions before the Delhi High Court on the same issue, and
Same writ petitioner.
uh, jurisdiction was there, so he has filed another writ petition.
In
And
respect of the stalls before the
Delhi,
Delhi railway station.
so and in that case, the next date fixed is 18/7/2024.
So you want this matter deferred?
Yes, Lord. In such
That the matter is issues already covered by the division bench, my lord. Under the new catering policy.
Division bench of this court.
My lord, this court, my lord. My lord, this order.
That order has traveled to Supreme Court.
Yes, Lord.
It has, but.
Is there a stay?
Not yet listed, Lord.
Not yet listed.
My lord, this is the order of the single bench, my lord, on this issue.
Where is the
My lord,
division
that
bench order? Where is the division
I
bench?
am
order?
getting, my lord.
Division bench has decided in writ appeals.
Right, third learned counsel, MS P. Chaudhary for the petitioner, Mr. H. Gupta for the railways. MS Chaudhary submits that the petitioner is agreed by the notice for vacating the stalls dated 2/3/2023. Petitioner runs what is the food stalls?
Yes, Lord. Catering
Stalls in the platform of Guwahati and Kamakya railway station. So this court, I'll bring notice and granted an interim
Status order.
status quo by
Order dated
27/3.
2023.
27/3. The learned counsel for the petitioner further submits that a similar writ petition is also prepared by the petitioner in respect of stall that he has in Delhi railway station, and which also an order was granted, and the matter is listed for hearing on 18/7/2024. So, furthermore, an order passed by the division bench of this court.
My lord, in WA number, my lord, 124 of 2023.
In writ appeal number 124 of
2023.
2023, dismissing the appeals filed by the vendor, is presently pending before the apex court.
It was filed by a partnership firm, Deepak and Company, another petitioner. He was writ appellant.
By a vendor.
Yes. It was a partnership. Rajendra Mangla is an individual. Lordship.
Paragraph 9, my lord.
It is submitted that SLP has been filed.
Yes, Lordship.
SLP has been filed against this order, and the matter is likely to be listed very shortly before the apex court. And a counsel for the table submitted to be deferred. Since the bench order passed in Repeal 124 of 2023, challenge submissions made by the Mr. Raj Gupta and that the matter still stands covered by the judgment of the division bench passed in Repeal number 12. He, however, does not dispute the convention of the petitioner that an SLP is filed. That view of the matter, let the matter be posted. On 22nd of July. And in order passed earlier will not be.
Grateful.
The parties are directed to apprise the court about the status of the SLP preferred against the judgment and order dated to the past 124 of 2020.
I shall do that. Much obliged.
My lord, my lord, this order, this case, my lord, the petitioner, all the petitioners who have been selected to get IY houses under ISY Y scheme, and the list has been prepared. But finally, my lord, beneath the list has been prepared. If you will also kindly see annexure 4 page. Six-one.
6-1.
6-1. This is the beneficiary list they prepared. But we found that we are not been selected. Then, my lord, they give the reasons why we are not selected. You also kindly see page 82, annexure 5.
Page?
Page 82. This is the reasons they mentioned that we are not entitled to get IOI house. Page 82, my lord. All the petitioners, the action remark rejection reasons, if they have been mentioned. Then, my lord, thereafter, we my complaint individually represented has been filed that we are entitled to get the houses under the schemes. Now, page 83, the lordship kindly see, they cause an further inquiry.
They cause a
inquiry has been page 83. With reference to the subject cited above, I have the honor to submit that 23 nongs of beneficiaries under Hatemira government who are rejected by system for ineligible. As per public demand, I have visited and found 23 nongs of beneficiaries out of 39 are eligible. This is the report. They wrote this letter to the Block Development Officer. And this is the page 84 is the list. Field verification report, last right hand column, they mentioned. Where 23 persons are eligible. Now, again, my lord, we come to learn that some persons, I mentioned in paragraph 14 and 15, the where earlier got the houses were again selected. I made them paragraph 14, lost of paragraph 14, my petition. I mentioned the details of the serial number, and I also annexed that list also annexed 8. All those persons were get houses, and they again selected. Whereas We have been not selected and we have been declared. But as the scheme is this, my lord.
What is the stand of the department?
They have filed an affidavit. If a lot of guys affidavit, very peculiar affidavit they filed, my lord. Paragraph, page 108, their affidavit, paragraph 16.
Yes.
They did not deny it, that those partners were selected. They said that their name may be deleted. Paragraph 16 of their affidavit.
Yeah.
Now you'll also kindly see, they have prepared another report, my lord. Page 113 of their affidavit, my lord. Another report without our absence. Without our absence. Our absence.
Yes.
This is the list again they prepare. And remark from last, my lord.
113.
113, Director A.
Then?
Again, contradictory report has been there, prepared and submitted it.
No, but come to page number 109.
109.
Affidavit.
109.
Now you read towards the end of the paragraph. It is pertinent to state. You found it? Page 109 is paragraph, end of paragraph 60. Later part of it.
It is pertinent to state here that the office concerned will conduct final physical verification before sanctioning the benefit when the new target is received. And if the said beneficiaries are found to be ineligible, or have already been benefited, then their name will be deleted from the state list.
But the final verification is still pending.
My lord, final verification is also going to conduct. I made an annexure 5, and thereafter annexure 6. Now they again prepare a list, give the reasons. They make a
That
verification.
is also not a final verification because the affidavit says it will be conducted.
But you will also kindly see this type of, if you are not filing the writ petition, then certainly they will release those houses, those persons. Now, after filing our petitions, they are now cautious, my lord. They make a statement, their name may be deleted. Why our name not
Have
be
you done
included, my lord?
final verification?
My lord.
My lord,
Now,
this
your lordship, I
this
just
is
say one thing.
basically a case of premature litigation, my lord, because as far as the role of the Gaon Panchayats is concerned, we do the verification process and hand over all the data to the central government. First of all, my lord, this case should be dismissed on the ground that there has been a non-joinder of necessary party. The central government releases the final list, wherein the names of all the beneficiaries is finally published. So at this point of time, my lord, the final verification process has not been done. The final list has not been out. And in fact, he ought to implement the central government, my lord, which he has not done.
Their son, if
Not necessary, my lord.
their name, your names are not there.
Not there.
Their names
Why?
are not there.
My lord, may peruse paragraph 3, the entire chain of events has been mentioned.
Paragraph 3 of
My lord, paragraph 3 of the affidavit in opposition. In fact, those beneficiaries who have benefited from the earlier schemes of the government, their names have already been excluded.
So you make a statement that
That is there. That is
these
there, my lord.
petitioners have
Benefited earlier.
earlier.
Yes,
Where
that is there.
Not here.
Well, I made a prayer here.
Paragraph
Let
18, my
I
lord.
not want
My
house.
lord,
You
paragraph
also will direct the authority, high level inquiry should be conducted. So many illegalities has
Not a
been.
public interest litigation. Is this a public interest litigation?
But our
You are interested in getting your house.
yes, my
You are agreed that your house has not been granted.
grant.
We are trying to find out why it has not been granted.
My
Paragraph 18, my lord.
18.
18 of my affidavit. In fact, my whole affidavit, if read in totality, my lord, it will show up the state basically why his case was rejected. Paragraph 18, my lord. That the statements made in paragraph 16 of the writ petition are partly incorrect, hence partly denied. It is denied that as the petitioners are the persons living under below poverty line having ration cards issued by the authority, as such, they are entitled to get a house under the PMEYG scheme. It may be mentioned that only those beneficiaries are eligible for a house under the PMEYG scheme who fulfills the required eligibility under the scheme only.
What is the eligibility?
Well, those details have been given.
Your affidavit does not specifically state why they are not eligible, if they are not eligible. You are saying that they denied their line, they don't satisfy. You give us the detail. What eligibility criteria they don't fulfill.
Then I'll have to file an additional affidavit, my lord, the grounds on which they.
Why your affidavits are never specific? What is the point in filing an affidavit? It's not
I'll mention those grounds in the next affidavit.
Let him file the additional affidavit. Explaining their stand. Why your cases have not been heard. The study council cannot be file additional affidavit. Bring on record. In response, why the claim of being granted. What is the housing?
Yes. P under PMAYG scheme.
PMAYG scheme. Paragraph 18 of the perusal of para 18 that while there is a denied satisfied requirement eligibility criteria F A F A Y scheme particular specific details about the learner's status whether the eligibility criteria by scheme and if they don't specific particular With the matter, it's 24. Oh, oh.
Hello.
The loss of life by wild elephant, my lord, I have already received.
You have received.
Yes, my compensation.
Okay. Yes, sir.
Yes, good.
Four.
Three to six.
Where is C? Three, four,
Three,
five.
two, 3, 4, 5, 6.
Right. There is no six here.
3, 4, 5, 6.
We don't have a six here.
No, six.
Four, five. They would have. Not correct.
Yeah, please, Lord. My lord, in this case, my lord, I am seeking 3 weeks time to file it.
File affidavit.
Lord.
Sir,
Z Islam.
there is some HCL and for 3 weeks time.
Lord.
File.
Interim.
Lord.
Obliged.
My lord, another similar matter is there. Let it be come up with WPC number 3001. Same petitioner.
That 3001.
Lord, 2023. Deeply obliged.
Obliged.
The notice has been served in July 2023, but still nobody has appeared on behalf of respondent.
What is it that you are claiming here?
Lordship, we are challenging a insurance ombudsman award. Lordship, we are an insurance company. We have repudiated the claim of respondent number 1. Thereafter, they have a complaint that the insurance ombudsman award goes against us.
It is submitted that what is the depth of the claim? Where is the award? Page number.
22 to 24.
Yeah. Award. Ombudsman. Insurance ombudsman. For the state of Assam, Meghalaya, Manipur, and Arunachal Pradesh. Whereby the order was passed by the spot. Whereby the insurance company was directed to settle the claim for the sum assured value, deducting their from the refund of the premium if any. So you have not settled it. Have you settled it?
No.
Why?
Lordship, no,
Is there any interim order?
Yes, Lordship.
By order dated 9/6/2023. Report by leaving report by staying the order. Since by the claimant writing that that an amicus that legal aid counsel be requested an appearance on behalf of respondent. Respondent one is it? Lady,
One is the better.
let registry appoint the counsel. The petition will be here to the legal aid counsel appoint that the matter be listed again on 12th of June. 12th of June. Copy of this order may properly this
My dear Lord. Firstly, in this case, my lord, the petitioner's father died due to road traffic accident, my lord. The government issued a notification, page 16, my lord, for providing an amount of rupees 2 lakhs excise duty and to the next of kin of the. May I pray, my lord, maybe disposed of with the direction to the respondent to verify in terms of the notification.
Have you filed the representation?
My lord, page 26.
26, the representative. And claims to be verified by the DC. Regard district. And he found to be genuine. The payable proposal will be sent to the respondent one, namely the Commission Section Department of Disaster. Revenue and Disaster. Thereafter, reported order passed. So DC will complete the verification within 60 days of date of and if found will be forwarded thereafter. Further 60 days in respondent path. If so, Yes, Purva, I will vote.
3 to 6.
Okay,
8, 4,
3 to
5.
6. A board of correspondence. No, we are also a dispose of, we are disposing it of. Directing the authorities to verify and pass necessary.
May I please, Your Lordship? Lordship, this matter regarding ex gratia, here Lordship, respondent number 3 file an additional affidavit in opposition, Your Lordship. In this affidavit in opposition, Your Lordship, if Your Lordship find page 31, the ex gratia amount already sanctioned in favor of the petitioner, but it has been not disbursed yet, Lordship.
Who is for the disaster management, please get your instruction. Third learning council for the party. It's submitted by the council. That pursuant to the filing of the writ petition, affidavit by the DC has been filed, whereby the proposal has been forwarded by the office of the DC Corbetta by communication dated. Whereby the DC has passed an order dated 25/1/2024, holding that an amount of rupees 2 lakhs have been sanctioned under the notification number so dated 12. As the next gratia in favor of the writ petitioner with the next of kin to the deceased person, late Anima Pathak, who died due to road accident, the Borbetta Revenue Borbetta. So, Learned Council for Library that because notwithstanding the order passed by the DC Borbetta and Chairman District Disaster Management Authority. No orders have been passed by the the amount has not yet been received. So, but it has been directed to be released to the petitioner one only.
Yes, Lordship, as
What
a
about
next
the
of
other
kin.
petitioner?
Other petitioner, Lordship, also minor. He has represented by the respondent petitioner number 1.
In favor of petitioner number 1. Not directed to be released in favor of petitioner 1. MSPR also.
Sorry, Lordship, petitioner number
hearing for the disaster management, revenue disaster. As for the respondents number 345 and 345. After 2 weeks.
Deep. Hello, kindly pass out the matter. My senior's leg on court number 20.
2 p.m. 2 p.m. Taken up.
Yes.
Yeah. Okay. Adjourned.
Chief, I may be allowed to keep time to file a affidavit matter.
The amen for the petitioner, Mr.
Bibi Hoya.
B.B. Goyal and hearing for the respondent submitted to praise for 3 weeks' time. File yesterday. Where made is not objected by the government. Magistrate, 3 weeks.
14 mile. 14. That was
Date. Any date after 3 weeks.
14.
Will it be 14?
Yes.
3 weeks.
Yes, 14.
14, all right. It's on 14.
Obliged.
Lordship, to my affidavit in opposition, they have filed a reply yesterday. I'm waiting for some instruction to that reply, Lordship. So let it come up on 3rd of June, Lordship, if otherwise nothing.
It is submitted by the learned CC. MS Sharma, appearing by them. An affidavit in reply has been filed by the petitioner. Response to the affidavit in opposition filed by the respondent. She submits that you would like to state the affidavit in reply. Raised for 2 weeks, 3 weeks,
No, Lordship. Can it be on 3rd of June?
raised for some time. Both councils submit the matter be listed on 3rd of June.
3rd of June.
Raised on 3rd of June.
Obliged, Lord.
What is your lordship? I'm praying for 3 weeks time to file our affidavit on behalf of Finance and Taxation Department, my lord.
Mr. your
H.
name?
Borua.
H. Borua, London Council appearing on behalf of the Finance Department. Raised for further 3 weeks time to file the affidavit. Mr. K. Todi does not object to the prayer made. Accordingly, matter be listed after 3 weeks. Supreme order passed again with
Much obliged, my lord. May I please, your lordship? Lordship, the fact of the case is, lordship, the respondent authority will demolish our house as lordship for construction of a wide road, lordship. About lordship 64-65 feet wide, lordship. Lordship, in this case, lordship, the petitioner are the dwellers of very old age, old village, lordship. Lordship, since the date of their forefathers, lordship.
Respondents, have you filed anything?
Yes, lordship, we have filed our affidavit. Affidavit was filed, lordship, and against this lordship, I have filed also an affidavit in reply, lord.
What is the stand of the department here?
Lordship, the land was granted to us by the circle officer. There is a availability certificate given to us, and as such, we have proceeded with the work. Lordship.
Where is that certificate?
Annexure
Page 60,
1,
lordship.
Annexure 60, like page 60.
And what is your reply to that?
Lordship, reply, lordship, from page 61, lordship, and one of the pages, lordship, I have annexed at page 66, lordship. This is the original existence of a road, lordship.
So the land which has been given to them is what land?
Land is a patta land, lordship. Where, lordship, we are,
Belonging to whom?
lordship,
Belonging to whom?
lordship, the petitioner, lordship. Petitioner patta land, lordship, in which, lordship, they have their dwelling houses, lordship.
Then the circle officer is required to file some status report for some,
Awaited, Lordship.
huh?
Instruction awaited. Some more time required.
You file it, heard Mr.
PU Laskaru.
PU.
Lordship, one thing, lordship. Same project have been started, lordship, in the adjacent village, lordship. And the same petition, another petitioner approached before this honorable court, lordship. I have annexed an order, lordship, at page, lordship, 53, lordship. Without initiating any land acquisition process, lordship. And this is a very old village, lordship. Operative party is at 54, lordship.
So that is why we want to direct the respondents, circle officer to file as to what process.
But in the meantime, lordship, some protection is required, lordship. Otherwise, lordship, they will demolish, lordship, our houses, lordship. We are very poor
Heard
petitioner,
learned
lordship.
counsel for the parties. The grievance of the petitioner is that over their patta land,
Yes, lordship.
the respondent with what department is this?
Water Resource
Water
Department, lordship.
resources. You are constructing it for what purpose?
Lordship, the existing embankment has been damaged in some places, Lordship. So that is being repaired and some strengthening work is
The
going on. Lordship.
Water Resources Department is required to undertake repair work for the existing impact. In which parts?
Lordship, village Lordship, village Lordship,
Village Ratanpur
Ratanpur area Lordship.
in the district of Hailakandi. Stop. The learned council for the petitioner submit that the land is their partner and the same cannot be acquired without due process of law. In response to the claim made by the Department of Water Resources, like that affidavit, and they have enclosed a copy of the certificate dated 23rd of November 2020, issued by the Circle Officer Hailakandi. The effect that the land required for exploration of under the jurisdiction of Hailakandi Revenue Circle is available. Now, this certificate does not give any indication of the land. How do you identify the land? Stop. What is the stage of the works?
Pardon, Lordship.
At what stage are the works?
Lordship, about 60% work has been completed. We have stated in our application.
They have started Lordship, the work Lordship from other side Lordship. Not still Lordship, they're not passed in our houses Lordship.
The council appearing for the resources submit that in view of the land being made available by the revenue department, the work has already proceeded, about 60% has been completed. It's S. Borwal and council permanent. However, submits that the revenue department does not file any affidavit. Upon hearing the council for the parties and upon approval of the pleadings available on record, you can see that the land which is stated to be available for the works to be undertaken by the Water Resources Department does not give any particular of the land stated to have been available by the circle officer Hailakandi. In order to decide whether the apprehension of the petitioner is genuine, it is necessary to understand the land available, land which is made available, the Water Resources Department for the restoration of the embankment. Along the, what is the IB? LB or IB? Number
LB, Lordship, is left bank.
Left bank of river Katakhap from Oroitoli to the confluence. Let the circle officer let the Deputy Commissioner Hailakandi place before the court by the next date fixed the particulars of the land for which the construction is presently being carried on, and also a statement on affidavit as to whether the apprehension expressed by the petitioner that the land belonging to them, the Patta land, and this construction work is likely to affect their land as well. And if so, whether any steps have been taken for acquisition of the land under the procedure prescribed in law. Let these information be placed before the court by 7th of June In the event this information not forthcoming from the office of the DC, court may proceed to pass restraint order on the basis of the apprehension expressed by the petitioner. List on 7, petitioner counsel is permitted to renew his prayer for renew his prayer expressing his apprehension the next week.
In the meantime, Lordship, they may not take any coercive action.
We have given that indication on 7th, we'll consider. Let a copy of this order be marked to the office of the senior government for onward communication. Copy of this order be brought.
Villages, Lordship, Ratanpur and Bahadurpur.
Ratanpur and
Bahadurpur.
Bahadurpur.
Yes, Lordship. 2 villages, Lordship.
Yes.
Your Lordship, we have filed our rejoinder on 20, your Lordship. The fact is that, your Lordship, we have filed our rejoinder on 2005, your Lordship. The fact is, your Lordship.
Have you received copies?
Lordship.
Yes.
You want to file anything?
Anything to submit?
Lordship, we have already, Lordship, in our affidavit, it is stated that his license period has already expired on 31/3, Lordship. After that also, he was given a notice to vacate the plot, Lordship, since the railway has undertaken some development works in this
License for what?
license to operate business, Lordship, in the railway land. These are the railway land. And he was running a
Division bench order which I came across in 3 matters before that is regarding the lease of the vendors on the platform.
Now, may I give you, your Lordship, a brief background of the case, your Lordship. What happened, your Lordship? We are in position of, no doubtly, it is a railway land since 1983. From 2015 onwards, railway started giving us temporary license, annually license, for payment of license fee. Accordingly, it was renewed and lastly up to 31/3/2023, your Lordship. So we made a represent, we are expecting that our license will be renewed. Now, suddenly they came up with the influence notice is 64, your Lordship. These are the list of the.
Where are the licenses issued?
Here.
License issued?
License, it started from issuing from 2015, your Lordship. Undoubtedly, it is a railway land. So after licensing, we are licensee oblique.
Very well.
We are the tenants, your Lordship.
We'll keep it for hearing, admission hearing.
My lord, may instead of admission, our urgency is there, Lordship. Project is installed, Lordship. Urgency is there, Lordship may fix in next week also, he have filed affidavit. Otherwise, he is as per the agreement, Lordship. Our project is central government project is installed, Lordship. Development of railway platform as well as, Lordship.
We'll have it on 30.
30. Lordship.
Since the treatings are complete, matter be listed for admission hearing on 30.
Lordship.
May.
Please, your Lordship.
Yes.
Lordship, my joint property was acquired for construction of road under Assam Mohammed Mala project, your Lordship. But in doing so, your Lordship, the building of my building has not been acquired, your Lordship. If your Lordship move on to page 16, your Lordship, you get an idea, your Lordship. Page 16, this is the picture, your Lordship. I have tried my best, your lordship, to protect myself from all the construction hazard, your lordship. But still, one post of my house remains outside on the road. There is a zero distance, your lordship, from the road to the house, your lordship. Your lordship, I have made several representations. I have been given verbal assurance, your lordship, but till to date, your lordship, nothing has
But
been.
your house, whether you have built the house closer to the road.
No, your lordship. My house was in that place from a very long time. The construction was done at a later stage, your lordship. The road construction has been done at a later stage, your lordship. Your lordship, as per my limited knowledge, your lordship, while constructing a road, your lordship, as per PWD norms, your lordship, distance of around 20 feet has to be kept, your lordship.
Because the light post which appears in the photograph
Lordship.
appears to be adjacent to your fencing.
Lordship.
Fencing.
Yes, your lordship.
Your boundary.
Your lord, this is not a light post, your lordship.
What is this?
This is my building post, your lordship.
Building post?
Yes, your lordship.
Outside your fencing?
Yes, your lordship, because I couldn't erect my fencing outside the building post because my fencing will be on the road, your lordship.
All right. Yes.
Recording department is PWD lordship.
Who is for PWD? Third learned counsel for the parties issued notice. We can move on. Notice issued, not issued.
Not.
Mr. N. Goswami appears for
2 and 3 lordship.
respondents 2 and
I appear for respondent number 1.
Mr. A. Bhattacharya appears for respondent number 1. And MS A. Bhattakur for respondent 4. If the respondents are represented, notices are waived, however, extra copies they furnish within a period of 1 week. Let the respondent complete their instructions and file necessary affidavit if so advised. Place after return of the extra copies to be furnished within the course of the week.
Right.
As I was continuing, my lord. Right, but I think the learned EG has come, so I can continue. My lord. If your lordships now will come, my lord, I mean, how, my lord, the place is sacred. At page 46, if your lordships come, there's only a few pages. Your lordship is aware, that's the Assam government portal, which, my lord,
Yes.
your lordship has that, my lord, just, there's Ma Kamakya, I'll just read the first paragraph, the rest is clear, my lord. Ma Kamakya or Kameshwari is the renowned goddess of desire, whose famous shrine is located in the heart of Nilachara Hill, situated in the western part of Guwahati, the capital city of the state of Assam, in northeast India. Ma Kamakya Devalaya is considered most sacred and oldest of the 51 Shakti Peethas on earth. It is the centerpiece of a widely practiced, powerful tantric Shaktism cult. Now, there are various temples. What are they located? I will not trouble your lordships with that, but your lordships knows that. Many of your lordships come to page 48. Page 48 is an article which was from David Kinsey. He is a very well-known author on tantric cult. Page 52, your lordship will come. Because this deals with Yogini and feminine devotees Kamrupa to medieval Coach Bihar. Page 52. And this is in reference to your lordship.
52, yes.
Yes, sir.
Yes.
Second paragraph. And this is in relation to Kamakya only. Yoni, because the worship of the group of multiple feminine divinities, that's not one temple as your lordship is aware, because Dasa Mahavidya. Of multiple feminine divinities seems to have begun much earlier than the time of actual temple construction. And there must have been a certain continuity and change in the tradition. At many sacred places, a particular geographical feature, such as mountain, rock, cave, pool, river, or pond, is considered as a vital object of worship rather than the temple structure itself. The temple simply serves to mark, specify, or objectify the sacredness of the local geography. The temple does not enhance the sacredness of the place so much as the place enhances the sacredness of the temple. In the case of the temple of goddess Kamakya, the innermost sanctum called Garbhagriha is a cave located below the ground level. The Garbhagriha is a small, dark, and reached by descending narrow, steep stone steps. Inside the cave, there is a sheet of stone that slopes downwards from both sides, meeting in a yoni-like depression some 10 inches deep. This hollow is constantly filled with water from an underground perennial spring. What I was referring to a lot. It is the vulva-shaped depression that is worshipped as the goddess Kamakya herself and considered as the most sacred pitha, sacred abode of the deity. The heavily speared vermilion paste on the stone symbolizes blood. It closely resembles the female genitalia. The Kalika Purana description of the yoni of the goddess Kamakya almost agrees with our observation. The Yoni Tantra mentions Yoni Garta, the cleft of Yoni, Several times it designates Kamrupa or rather the shrine of the goddess Kamakya. Garbhagrihas, now that's the other temple. Garbhagrihas or the temples of the Mahavidyas are relatively small and not well embellished compared to that of Kamakya. However, the actual object of worship of each temple is more or less the same as that of Kamakya temple. That is the uniform stone filled with water. These are the two paragraphs I want to show. Then video lordship will come to the archaeological aspect. There's another article from IIT Guwahati, page 77.
Yes.
At 7, this is the understanding, the pattern and distribution of sculpture and architecture remaining in the archaeological site of Kamakya, the Priyanka Tamta and Sunkarnia Sharma, the Department of Humanities and Social Science, IIT Guwahati. Page 78, your lordship may come.
Yes.
With the heading 2, Kamakya Temple as an archaeological site. The Kamakya temple complex is one of the most famous Shakti goddess shrines in India, is also considered an important center of Tantrism. The sacred abodes of the goddesses are known as Pithas and not Tirtha. The term Pitha emphasizes the land-rootedness of the Hindu goddesses and also carries a sense of fixation of goddess worship at that particular site. The archaeological site of Kamakya is situated on Nilachal Hill on the western part of Guwahati in Assam, India. The temple complex covers approximately 1.25 square kilometers or approximately 308.9 acres. At the Kamakya temple site, more than 17 temples are dedicated to different deities. Most belong to the Shakta goddess tradition, like the temples dedicated to Dasa Mahavidyas. The rest of the temples are devoted to different forms of Shiva known as Bhairava, such as Aghora or Heruka Shiva, Amratakeshwara or Sajyota Shiva, Kameshwara or Vanadeva Shiva, Kotilinga or Daipurusha Shiva, and Siddheshwara or Ishana Shiva. As an archaeologically important site, Kamakya temple complex has an approximately 1516 habitation history, which began in the 5th century AD. As mentioned in the Umachal Rock instrument and continues to the present day. Over this period, the site was patronized by different royal houses from the Varman dynasty, Palasena, that's 4th century to 10th century AD, Palasena 11th to 12th century AD, Koch 14th to 16th century AD, and then the Ahom 15th to 18th century AD. This can be witnessed in different styles of art and architecture. It was here that the Nilachal temple architecture, famous for its bulbous polygonal domes, originated. This particular style of temple emerged during the Koch period, 14th to 16th century AD, and became the most popular style of the temple architecture during the Ahom period, 15th to 18th century AD. Throughout its history, the Kamakya temple site has seen tremendous changes in Hindu temple architecture, style from Nagara, North Indian Hindu temple style, to Visara, Central Indian Hindu temple style, from Pancharatna to Sapta Ratha temple form. Construction material also changed from stone to bricks and lime mortar. Terracotta tiles or plaques were used also in the temple buildings as evident from the Namak Kavali temple. These changes happened gradually over the time of period of approximately 15-16 years. During these periods, the temple complex not only experienced the socio-economic changes in the Brahmaputra Valley, but also religious changes since the 5th century. There was a continuous struggle between different faiths and power, beliefs, faiths and power with the dominant authority of the site. In the process, powerful belief systems subsumed minor ones into larger doctrines of belief, and the temples evolved from a cave temple to a complex of 17 temples. Religious practice evolved from the worship of water. This is very important. An element of nature to the worship of 10 different forms of goddess with the 5 male concepts. These changes make the temple site a suitable ground for research. In the sanctum sanctorum of the majority of the temples, the deity is worshipped in a non-anthropomorphic form. That is, there is no deity. These exceptions are the temples of Tara, where a bronze image of the goddess is worshipped, the Kotilinga temple, where a ribbed linga with a bulging body is worshipped. The focus on non-anthropomorphic forms is not found in other Shaktipitas. It is not found in other Shaktipitas in India, except the temple of Sambaleshwar in Sambalpur in Odisha and the Ugratara temple in Temple, where a sanctified water pit and a large block of flat are worshipped. Here in the Kamakya temple, the vulva-shaped depression on the flat bed of rock is worshipped as goddess Kamakya. The depression always remains moist because of the presence of a perennial underground stream. Now, this is the objective, but I'm showing the archaeological importance. Now, the archaeology will come to page 92. Okay. Page 92.
Yes.
Are the alphabetical list of monuments notified by the Archaeological Survey of India. And if your lordship will turn over the page at 93, the bottom 30 and 31, as far as Kamakya is concerned, it's a very interesting that the Daur Garila rock inscription of Kamakya, Guwahati is at 30, and rock cut figures and one stone Kamakya Hill. Their only protection. that is probably because they are at the bottom of the hill and why they were declared to be deemed for protection or not otherwise. But that is the advantage which is being taken. Today, this is being run like a PWD project. PWD will go and some contractor, LNP has been engaged and they will do the construction. Now, my lords, if your lordships will see, I can the act, my lords, the act. Can you hand over copy? Ancient National Monuments Historical Protection Act. Give them a copy of. National Act Commission? Oh. Because the Assam Act is parameteria of 59. If your lordships will, I just want to show your lordships the definition. The first, if your lordship says page 2A.
Page number?
Oh, sorry, not section 2A. I'm sorry.
Section 2A.
Ancient monument.
Yes.
Your lordship has that?
Yes.
Means any structure, erection or monument or any tumulus or place of interment or any cave, rock, sculpture, inscription or monolith which is of historical, archaeological or artistic interest and which has been in existence for not less than 100 years and includes the remains of an ancient settlement, the site of an ancient monument, such portion of land adjoining the site of an ancient monument, the means of access to and from. So basically 100 years. The key is 100 years. Admittedly, today this is an ancient monument. It is the Assam government also which says so in its portal. I mean, if you have to go on admitted facts, I mean, everybody knows it is. Now, let us, your lordship now comes to section 3, because that is where the catch lies and why, because it was not protected, declared as a national monument and consequently not protected. Now, section 3. Certain ancient monuments deemed to be of national importance. All ancient and historical monuments and all archaeological sites remain which have been declared by the ancient and national historical monuments, archaeological sites of the 1951 or by section 126 of the Reorganization Act to be of national importance shall be deemed to be an ancient and historical monument or archaeological sites and remains to be declared to be of national importance for the purposes of this Act. Now, let's also under section 4, the central government has the power to declare ancient monument to be of national importance because this was prior to the Act coming into force, and section 4 is prospective of the Act going forward. Where the central government is of the opinion that any ancient monument or archaeological site remains not included in section 3 is of national importance, it may by notification in the official gazette give 2 months notice of its intention to declare such ancient monument or archaeological site and remains to be of national importance, and a copy of such notification shall be affixed in a conspicuous place near the monument or site as the case may be. Now, there's interest, objections, etc. And then finally under subsection 4, a notification published under subsection 4 shall unless and until it is withdrawn be conclusive evidence of the fact that the ancient monument or archaeological site remains to which it relates to the national importance for the purposes of this Act. So it has to be declared, which is not. Here only a gateway which is peripheral and an inscription which is of 1732. The Dorgarilla inscription is actually by Gorfukan Millers. I checked it up. Now your lordship will come with section 20. There's an amendment to the Act which was carried out in 2010. Prohibition and regulated area. Section 20 capital A. Is here section 20? Section 20 capital A.
Yes.
So it's 20 capital A, my lords. Declaration of prohibited area and carrying out public or the other works prohibit in the prohibited area. Every area beginning at the limit of the prohibited area or the protected domain as the case may be and extending to a distance of 1 meter in all directions shall be a prohibited area in respect of such protected area or protected monument. Save, I will not read the provisos. In fact, the central government may on the recommendation of the authority by notification in the official gazette specify and appear area more than 100 meters to be a prohibited area having regard to the classification of any protected monument or protected area as the case may be under section 4 capital A. Save as otherwise in, I'm reading subsection 2, provided in section 20C, no person other than an archaeological officer shall carry out any construction in any prohibited area. So 100 meters is the area. Then 20 capital B deals with regulation and protection, but that 100 meters is basically that any changes to be carried out, it has to be done only by the archaeological department. Now, my lords, I have already shown you.
What is a protected area as defined?
Protected area is in terms of speech actually section 5 mentions it.
Any archaeological site.
2 I know. 2 sorry. Which has gone? Oh, protected area. Yes, which has to be declared. I'm sorry. 2I.
Yes.
Your lordship has it. Protected area means any archaeological site and remains which is declared to be of national importance. So section 3 and 4, unless it is declared, then it does not become protected. Here today, that omission is working to my detriment. And when it is admittedly one of the most important. Now, my lord, I have already shown your lordships at page 96, the changes which they have proposed along with the map, etc. I will not trouble your lordships with that, but essentially which will entail huge amount of digging, etc. Now I will take your lordship to page 192. The notice inviting bid.
192.
192 is the notice inviting bid.
Yes.
Detailed notice Assam government.
Yes.
In continuation of press notice issued via this office number dated 22nd November, the Chief Engineer PWD Assam invites online e-tenders in a two-bid system on engineering EPC mode basis from eligible firms and contractors for the work for the following work having eligibility criteria laid down in EPC document. However, successful bidders who are not registered with the APWD will have to get themselves registered on the Assam PWD building in appropriate category for award of work. Now, if your lordship sees the Ma Kamakhya, the name of work in the table, Ma Kamakhya Temple Access Corridor at Guwahati, Assam, Part A EPC, that's 320 crores. So that part A is now under consideration. And at Malad, that page, I will now show your lordships the nature of the civil works at page 200. Because that is very important. The kind of works which are being envisaged. Your lordship, at page 199 it starts, but brief particulars of the work your lordship will see. And I will show your lordship the development of the site, because that is my main concern today. Nobody can, my lords, quarrel with beautification or ease of access to pilgrims, etc. But 200, my lords, brief particulars of work 199 and 200 is the scope of what will it entail. Your lordship will see development of site, the first paragraph there. Your lordship, development of site, temple road, pathway and parking work, temple entrance, gate, landscape and horticulture, planter with sitting bench, RCC planter with skylights, stormwater drains, contour site, soil cutting, filling, disposal, retaining wall to counter level difference. A retaining wall, my lords, where you are going to have 5 floors will entail at least 300 feet of digging, at least, if not more. In complete campus, demolishing of old buildings, improvement of street facades, stump and street baller. And now your lordship will come to the last paragraph, which is why I say, my lord, they are not dealing with it as a heritage or a sacred or religious site. Today the sensibilities, because today what is it is required? Obtaining mandatory approvals, pre and post construction from all local bodies, state and central authorities, municipal corporation, environmental impact, fire clearance, forest clearance for the complete works in the scope of this project. Approvals as per latest Assam building bylaws, town and country planning bylaws with up-to-date correction slips, necessary environmental clearance on the appropriate authority, NOC from fire department, NOC from Airport Authority of India, and any other statutory approval, central licensing approving authority related to building for office of working, building from building approval from authorities required for commencing the work, execution of work and services, handing over the asset. But it is like building the guest state guest house next door. And your lordship will come to page 201, where it shows the number of floors. Your lordship has page 204. At the bottom in the tabular, number of floors, basement LG plus GF plus 2, which means 5 floors. Your lordship sees the top row, GF plus 2. Pilgrim management, multi-utility block, pilgrim management block, ground floor, whatever is at every level. The corridor will be at LG GF plus 2. So all of that, and it's all of us, we know that is all rock, because there's nothing else. At page 208, your lordship will come, is where the work order has been awarded, with the notice to proceed.
Page
208.
Yes.
Pursuant to your furnishing the requisite performance security and signing of the contract for the work, Ma Kamakhya Temple Access Corridor at Guwahati, Assam, on engineering, procurement and construction mode under PME Divine Scheme at your own quoted price of rupee of 428 crores and 50 lakhs, restricted to only part A amounting to 401 crores. You are hereby instructed to proceed with the execution of the said works in according with the contract document. No time extension will be allowed for the work unless there is justified and valid reason. Rate as per so financial time of completion 24 months. Now, my lords, this is my submission on the facts. As far as my, I want to, I'll just show 3 judgments. And I'll show you your lordship, my prayers also, before I take your lordship to 3 judgments that I want to show. My lords. What are my prayers, my lords? At page 41, my lord.
Yes.
So, my lord, page 40, I read, it starts at the bottom. I read in the nature of satiation. It's not be issued, quashing the impugn notice dated 15th of March 2024, where he has been directed to produce. Then prayer B is in the rate and the nature of mandamus, not to give effect to the impugn notice. And then prayer C, my lord, the writ of mandamus shall not be issued to the respondent, particularly the Archaeological Survey of India, to forthwith pass necessary directions to declare the Kamakya temple complex as the ancient monument of national importance by exercising powers under section 4 of the 1958. A writ of mandamus directing the director of archaeology to India to forthwith to declare the Kamakya temple complex as a monument under the Assam Ancient Monuments Act. This is the Department of Culture, because there are two acts, all paramaterial. A writ in the nature of monument shall not be issued to conduct a detailed hydrological. Well, prayer E is very important because detailed hydrological, structural, and ecological study of the impact.
Who is to conduct this study? Who
They
is
have to do
supposed
it.
conduct?
Some independent authority.
Who is the authority?
Well, look, today the proposal has come from the government. I think.
What do you mean by a hydrological study?
Hydrological study is that today the sacredness of the geography is derived from the underground springs and the underground water bodies which are fed from it. So maybe something like the central groundwater body, or it can be IIT, any of these specialized institutions also. But then that impact assessment has to be done. You're digging 300 feet. Today, if you are large.
Impact assessment perhaps has been undertaken through the environmental authority. Perhaps.
No, it says they are to undertake environmental impact assessment. It has been left to LNP.
Prayer is for hydrological.
Yes, that's very important.
Hydrological study.
Yes.
Now, how is hydrological study different from environment impact assessment? Or is it included or is it excluded? Or is there a specific authority?
Normally, what your lordship
you have made a pertinent point that it needs to be declared to be an ancient monument.
Please, Malad.
The entire complex. Now, we'll ask the state to respond to it. But insofar as the hydrological study is concerned, who is the authority?
It could be the Central Groundwater Board.
Or not could be. We want a specific.
IIT Guwahati, Malad. Because these are specialized bodies who do it.
What is the purpose of a hydrological study? You see, you give it to a dependent, let us say, archaeological study. There is the central government authority.
Absolutely.
Whatever report they give, you may accept, may not accept the different.
Please, man.
But there are other archaeological experts, independent or otherwise,
Please,
who can also be called for to give a study.
I am grateful, Malad.
Now, they may have converging or divergent opinion.
Please,
how does the court decide which opinion is beneficial for the particular?
As far as archaeological goes, Malad, I think the act is very clear.
No. I'm just giving you an example.
I follow what your lordship is. So today, but at least, but there is nothing disclosed. So let something come. Nothing is there. In fact, RTIs, I have annexed RTIs. Now, I will just show your lordship the nature of my right, because that's an issue I know they will going to read. Give him this one, Riju Prasad Sharma. This, this is the judgment, Malad. I will not trouble your lordship, excepting my locus part. This dealt with who were the electoral college for election of Doloi. Now, Malad, at paragraph 39, there are 4 families they have held earlier. The court, Malad, this is a appeal from Justice Amitabh Roy's judgment when he was sitting singly here in the Supreme Court. They held that 4 Borderi families, to which I belong. Here, paragraph 39, I will read only one sentence. In view of discussions made earlier, it is evident that the Borderi families enjoy a distinct status and monopoly in matters connected to the religious as well as secular management of the temple of Sri Ma Kamakya. And hence the claim of equality on behalf of the Deoris associated with the Nanan Devalayas or even with the Ma Kamakya temple does not have any merit. So that is different. But my right, I am a member of the Borderi family. My right for the secular and religious management is upheld. So the infringement of my right under Article 25 is direct. Now I will, my lord, show your lordships.
Yes.
This is on the locus part. The other one, Commissioner of Police versus 2004 12 SEC, your lordships. This is, my lords, paragraph 9, your lordships may come to. This judgment, my lords, relates to the Anand Marga sect, if your lordship will recall, because they were very violent earlier. When we were young, I think there was a lot of news about it. Whether they could do the Tandava dance. So whether it was an essential part of their religion or not, that was for the consideration of the Supreme Court. But then it dealt with how is this right to be adjudicated? Paragraph 9, if your lordship's own mind. The protection guaranteed under Articles 25 and 26 of the Constitution is not confined to matters of doctrine or belief, but extend to acts done in pursuance of religion, and therefore contains a guarantee for rituals, observances, ceremonies, and modes of worship which are essential or integral part of religion. What constitutes an integral or essential part of religion has to be determined with reference to its doctrines, practices, tenets, historical background, etc. of the given religion. There are reference to various judgments. Now, I will skip that. What is meant by an essential part or practice of a religion is now the matter for elucidation. Essential part of a religion means the core beliefs upon which a religion is founded. Essential practice means those practices that are fundamental to follow a religious belief. It is upon the cornerstone of essential parts or practices that the superstructure of a religion is built, without which a religion will be no religion. Just to determine whether a practice, part of or practice is essential religion is to find out whether the nature of the religion will be changed without that part or practice. If the taking away of that part of practice could result in a fundamental change in the character of the religion or in its belief, then such part could be treated as an essential or integral part. There cannot be additions or subtractions to such part because it is the very essence of the religion, and alterations will change its fundamental character. It is such permanent and essential parts which are protected by the Constitution. Nobody can say that an essential part of practice of one's religion has changed from a particular date or an event. Such alterable parts of practice are definitely not the core of religion, whereupon the belief is based and religion is founded upon. This can only be treated as mere embellishments in a non-essential part of practice. They were dealing in this context in the present case. Here today, my lords, the archaeological report which I showed to your lordships, the other part which I showed to of that tantric, they all say the place is sacred. The temple is a structure. The temple is not sacred. It is the place. It's the sacredness of the geography, the sacredness of the spring, the sacredness of the underground springs that flow. And now, so that which is why that needs to be protected, and that is why I'm invoking my right under Articles 25 and 26. The last judgment, the last judgment is something similar to this one, because earlier this relates to that Viceregal Lodge in Shimla, which is now the President's, I think, the summer retreat, which was proposed to be converted to a 5-star resort. Then, what happened was a public interest litigation was filed, and the court in the pendency passed orders directing them. All of it is history of how paragraph 14, your lordship may come.
Yes.
Because how basically, because I think it's an order dictated in open court, so it is.
Yes.
Paragraph 40. In this backdrop, when the writ petition was filed by way of public interest litigation, the court issued Rule Nisai on 19/11/1990 to all the responses. Initially, a stand was taken in the counter affidavit filed by the Union of India that they decided to use a part of the area for commercial purpose and the rest of the building to maintain and restore the glory of the Viceregal Lodge. That the decision to convert the historical building into a tourist hotel was sought to be justified on the ground that the Ministry of Tourism has encouraged a scheme of heritage resort, which essentially means preservation of the old properties and the use in such a limited commercial manner as to generate enough resources to ensure that the property will not crumble. As regards the construction of 5-star hotel in the area, it is stated thus. The premises may not necessarily be converted into a 5-star hotel as commonly known, but the concept plan will be more of a heritage resort, which could enhance and project the cultural identity of the area instead of destroying it. This court was not satisfied with the counter affidavit filed on behalf of the Government of India. Therefore, it gave directions on 24th of November 2095 to have the matter reconsidered by the Cabinet Subcommittee. Accordingly, a counter affidavit was again filed on 22nd of January 96 that in August 1982, the Union Cabinet took a decision that the Indian Institute of Inverse Study, which is housed in the Rashtrapati building, could be shifted to some other building. So, Milas, I will skip this part because what they did. Then you'll actually come to page 16.
Yeah.
Because there in the counter affidavit, they admitted that it will be preserved as a national monument. So therefore, the directions, this court observed, paragraph 16, that since the Government of India had admitted in the counter affidavit that the national building part of the appurtenant land would be preserved as a national monument by the Archaeological Survey of India, the question was arises, what would be the appurtenant land? So there in the court proceedings, it was directed to be, they admitted and it was declared as a national one. And at paragraph 19, they gave directions as to how then it was to be gone about.
Yes.
It is needless to mention that as soon as the Indian Institute of Advanced Studies vacates the building and lands, hands it over to the archaeological department, the government should provide the necessary budget for effecting repairs and restoring to the building its natural beauty and grandeur. It is also necessary that its proper maintenance and preservation is undertaken as an ongoing process to protect the historical heritage, and needed repairs are effected from time to time. We avail this opportunity to direct the Government of India to maintain all national monuments under the respective acts referred to above, and to ensure that all of them are properly maintained, so the cultural and historical heritage of India and the beauty and grandeur of the monument sculptures secured through breathless and passionate labor, workmanship, craftsmanship, and the skills of the Indian architects, artists, and masons continue to be preserved. They are the prides of Indian. They are the pride of Indians and places of public visit. The tourist visitors should be properly regulated, and collection of funds by way of admission and entrance should be conscientiously accounted for and utilized for the upkeep and maintenance under the respective regulations. Advocate, etc., should be provided. So, how it has been done in the US. So, essentially, in the course of the proceedings, since the government itself decided, but then it was done on the court. It was declared as a national law. So, today we have a temple gateway, an inscription of 1732, which is declared as a national monument. But the main temple complex, it is not. And which is why, because today, which is what they are doing. When it is being proceeded upon, the PWD is, you have to take only municipal clearance, you have to take some bylaws, building bylaws, and all of that. That is where the nub of the issues, and we want, nobody can quarrel with the proposition you need the ease of access to pilgrims, but it cannot come at cost. Because today the repercussions and the ramifications are, it's a very delicate ecosystem.
What are the provisions of the Assam?
It's a parameter. No? Three protected monuments. The state government may by notification the official gazette declare an ancient monument to be a protected monument within the meaning of the act.
Okay.
Ancient monument definition is the same 2A. Protected monument may by notification declare, and notification shall be published, etc.
Yes.
And once that section 15, which is an additional protection in Assam, which is not there in the National Act. In the a protected monument maintained by the state government, section 15, under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. Now, today, this is the duty which is actually enjoined upon them. But if the construction has that effect, then the whole purpose of the character of the Kamakya temple itself goes. So the character of Kamakya temple is derived from the water, the holy underground spring. So we have an additional protection in Assam Act.
Yes.
And there's also a PIL. I know my learned general says that. We have a copy here.
Regarding the land, part in and two.
No. They filed on this issue, but they only asked for a white paper. It is a PIL filed by some devotee, and they have not challenged this. They have not challenged the construction, the notice inviting tender, and all that.
What is the order passed here?
I don't know. I think it's pending for completion of pleading. Because it was filed without any imminent threat or damage. But today we have a work order. I mean, challenging a work order. So for me, today the status quo is very important. They have there is no challenge to any work.
Also, they want a white paper on the Kamakya temple access.
White paper, white paper is neither here nor there. It's at the end of the day, someone has to.
Yeah.
Okay.
Yes, Mr. Advocate General.
Yes, page 107 of the litigation.
Yes.
Request for proposal, consultancy service for the work of Ma Kamakya temple access corridor at Guwahati. So where is this access corridor will be located? That is very important. Now, Lordship will kindly come to page 112. Introduction. Authorities, the Governor of Assam, acting through the Public Works Department and NH Department, Government of Assam, and represented by the Chief Engineer, PWD, plans to take up the consultancy service of Ma Kamakya Temple Access Corridor at Guwahati, Assam. The indicative cost of the project is so and so. Now, background and aim of the project. This is very important. The government of Assam has aimed to develop Ma Kamakya Temple Access Corridor. Over the period, the number of devotees have increased manifold, and post-independence, no work as such has been undertaken on large scale to upgrade the facilities. The facilities as proposed will provide easy access, public amenities to pilgrims visiting the temple complex. For the convenience of senior citizens and physically disabled people, lift and escalators are being provided as per harmonized guidelines of MOHUA. In long run, it will provide the devotees convenient way to worship goddess. During restoration and upgradation of facilities around temple, it should be ensured that the beauty of the temple is preserved. No tampering should be done with the architecture of the temple. The corridor should be constructed by keeping the ancient sculptures undisturbed. Where this proposed corridor is being planned, Lordship, it is beyond the campus of the temple. Nobody is going to set a single foot inside the main temple area, including the boundary. What we are trying to do, a affidavit in that PIL has been filed by the Chief Secretary, saying very clearly, I'd like to give one copy because that will clarify Lordship's whole idea. The existing commercial establishment, my client was sleeping. So many hotels have sprung up in that area. So many other shops. All are growing clandestinely, Lordship. Nobody at any point of time raised any objection. And there are residential complexes also. If Lordship is pleased to look at this affidavit, we have clarified what is relevant here also. So the background, etc., we have quoted in paragraph 3, which I have just read. Then what this page 289, Lordship will see that. Broad facilities to be provided are cloakroom, ticketing counter, etc., information center, utilities, souvenir shops, multi-utility block, designated entry, VIP and public, trust office, bhojanalaya with kitchen, public utility, restaurant, library, VIP lounge, VIP buggy service on terrace, pilgrim management block, multi-purpose hall, queue management zone, pilgrim holding capacity of third floor, 14,000 people, utilities, prasad block, shops, etc. Then Lordship will kindly come to paragraph 4. The deponent respectfully begs that the Ma Kamakya temple is not an archaeological site as per the provisions of law, and the project undertaken by the respondents has nothing to do with the puja, podiyati, etc. of the Ma Kamakya temple. The project in question is for the pilgrims and management benefits of the pilgrims. The area on which the project in question is to be executed is presently marked by unplanned residential and commercial buildings. All are to be removed now, which restricts the free access to the Ma Kamakya temple and negatively impacts its visual and aesthetic character. The project work has aimed for creating public open spaces, pilgrim amenities, facilities for all-weather access corridor for pilgrims along with periphery, including free access to the elderly and differently able people to all the shrines. Then, next paragraph. In Kobindra Prasad case, Lordship, this issue went up to the Supreme Court. If Lordship is pleased to come to page, because I'll go to the affidavit once more, but there is a Supreme Court order also, page 300 of the affidavit.
Yes.
In Kobindra Prasad Sharma versus Chief Secretary, Government of Assam, paragraph 4. In paragraph 5 of the affidavit dated 3/9/2023, filed by the state of Assam, it is mentioned as under that moreover, it is to be brought on record that in a meeting that was held on 13th August 2023 at the Chief Minister's office, presided over by the Honorable Chief Minister Assam, to discuss matter relating to Ma Kamakya corridor and associate aspects. It has been decided that at present the Doloi Samaj is running the affairs of the temple administration satisfactorily in close coordination with the local administration, and the current system may continue. Now, thereafter, I'm not reading the relevant other parts. Then now coming to page 302, paragraph 6. In the above mentioned affidavit, there is an assurance that the government of Assam is taking up the developmental activities of the Ma Kamakya temple in a big way under the PM Divine scheme. Now there is also an assurance that the amount of 11 lakhs so and so lying at deposit in account number so and so will be handed over to the Doloi Khamas, Ma Kamakhya Dewalaya, and thereafter the account would be closed. The earlier affidavit record that at present Doloi Khamas is satisfactorily managing the affairs of the temple in close coordination with the local administration, and the current system may continue. Therefore, the impugn orders need not operate now, and we direct that instead of the impugn orders, what is recorded in the aforesaid affidavit of the state government and the prevailing arrangement for managing the affairs of the temple shall continue. We take on record, this is important, the assurance of the state government that it will be taking up developmental activities of Ma Kamakhya temple in a big way under PM Divine Scheme. The said assurance shall be abided by the state government in its true letter and spirit. So we have disclosed everything before the Honorable Supreme Court, what we are going to do. And this PM Divine Scheme, there are a series of meetings at the Prime Minister's office where all the authorities, all the stakeholders are present. Nobody has raised any objection. And therefore, what my learned friend was showing, page 200, that all these permissions, page 200, the last paragraph, obtaining mandatory approval, etc., from various authorities. So these are made mandatory. Nobody is going to violate any of the laws while constructing and implementing the PM Divine Scheme for Ma Kamakhya Temple's corridor. Nobody is going to do that. And what is his status? Now coming back to the affidavit now, what the assurance we have given to the division bench of this honorable court. That paragraph does page 291. The second part is relating to the judgment order which I have just placed of the Honorable Supreme Court.
Yes.
Now coming to paragraph 9. The deponent denies that the construction of the proposed corridor would require mass demolition of the existing old structure and shredding of the Nilachal Hill, which has many temples, including Ma Kamakhya temple and others. The deponent also denies that there will be large-scale removal of existing important structures and cutting of rock, etc. In this regard, the deponent reiterates and reaffirms the statement made in paragraph 3 and 4 of the instant affidavit in opposition, and respectfully state that the project in question will be implemented without interfering with the architecture and ancient sculpture of Ma Kamakhya temple and other temples in and around the area, and by not violating any existing norms and statutory laws in force. Paragraph 10, last 3 lines. The authorities have also taken all steps to maintain the glory and sanctity of Ma Kamakhya temple, and after considering all aspects only, steps have been taken. Now, next paragraph 11. May I read the whole paragraph? The deponent state that the petitioner have misconceived and misconstrued the PM Divine Scheme and made various statements on assumptions and presumptions, referring to another scheme of the central government, namely Prasad scheme. That is in response to the...
You are reading from which affidavit? This
The
affidavit?
affidavit we filed before the division bench. The facts I am placing actually, Lordship.
Para 11,
Para 11.
page 293.
293, yes, Lord. Because this is the same stand will come here also. The deponent further denies the allegation that the main interest of the respondent is
He's projected a case on a slightly different.
on a slightly different, but for that, his personal right has to be violated.
No. We'll go into that. What he says that this is not, and which perhaps may not be, probably may not be disputed by the state also.
Lordship.
This is not about just one temple. It's not about one particular area, specific area, which is considered to be sacred or mental or archaeological or whatever term you use. He says that this process of worship of the goddess is not just one goddess. There are many. Now, therefore, the places of worship are spread over.
Yes.
A large area.
Yes.
As on date, perhaps from what he has said, subject to correction, these are not protected under the ancient monuments.
Absolutely.
Now, that being so, where is the requirement? If it is protected under the monument, then the authorities who are prescribed under the Act, they will have to give a sanction or an
Yes.
NOC.
Yes.
Now, since they are not protected, who monitors whether the temple's sanctity in terms of changing of the landscape or structural design, etc., is affected. Number one. And he says he is referred to certain civil works that the floors are going to be raised, that many number of floors. Of course, subject to what reply comes from. Essentially, what he says is that this, being a very ancient form of worship, is not just one idol or one temple which needs to be protected.
This Kamakhya corridor, Lordship, Kamakhya temple access corridor, Lordship, is related to Ma Kamakhya temple. And there are about 12, 13 temples within that campus.
Correct.
Nothing is going to be touched. When I say Kamakhya temple, the list, the other day I went, 12 temples names are there, Chinnamasta and all those, Bogola Devi, all this, those all comes under that same scheme. So now this access area, when I have
the anxiety which he is offered.
His anxiety is, Lordship, it may not be correct at all.
It may not be correct, but we are just thinking aloud.
Because we made a submission before the division bench that not a single person from that area has come.
Therefore, he has come.
Most probably. Because the PIL has been filed by one person from Guwahati and rest are from Pan India. That was the question put by the division bench also to them.
And therefore, he has come after a long slumber.
Yes, it is an afterthought.
Anyway.
That is why more or less the case is similar.
No,
but I am not the,
no, it's not about
but my thing is that very clear.
Mr. Advocate General, it's not about that. It's about the protection of a particular
Protection,
place.
absolutely, Lordship. But protection, it is his personal duty or it's a public duty?
No, correct. But how is the government going to ensure?
Government,
unless
Lordship,
you say
I have to place the minutes of the meetings of the PM Divine Scheme.
No, but why is it not in this? Why is it not covered under these acts? There's an Assam Act.
There are a lot of acts, lot of temples which are not covered under the acts. If the acts cover this one, the whole structure and whole management will go. If he is saying that 100 meter.
State Act protects us.
No, if individual cannot come and
tell.
tell.
The method and worship house will not be changed. There's a very old.
Lordship, this act is of 80, 70 years old.
It's still in force. Section 15. And in any case, in the judgment I showed to your Lordship, it says that the Doloy Khamaj will have complete right over the secular and religious management.
That area we have not entered into. My friend is complicating.
You are correct. We accept your.
There is two different aspects. One is the religious part. One is the religious part.
No, Mr. Counsel, please understand. We accept your statements. But who is the authority to decide?
That authority will definitely respond. Lordship, I cannot say
exactly the
authority
who will decide that these structures or the sanctity.
Now, what is his main trouble? What is his main trouble? That the institution, the temple is not covered under the acts. That is a totally different subject. But what about now? Why he is aggrieved now? At this, what has triggered him to come before this honorable court?
He is expressing an
apprehension. That apprehension will be definitely taken care of. But what is his personal right affected? It is not come under Article 25 and 29.
Right to worship under Article.
Right to worship. My submission is very clear here. That his right to worship will not be affected by a single inch also. In our affidavit, the Chief Secretary's affidavit says, it has nothing to do with the religious practices, which is going on for years, for centuries.
See, if there's let us say a structure.
No. What is it now? Let us look at my affidavit. What we are saying, what we are going to touch, we are going to touch some of the residential complexes and some of the commercial complexes.
Well, you point out that he has personal interest there.
No, personal interest. That is why I want this petition to go along with the PIL. That will be my prayer. Because the main core issue is same. What has triggered him to come before this honorable court today?
That was the first question this court put to the petitioner.
What has triggered him? Because we wanted to develop the area.
Environment bed. But he says his rights under 25, 26 are affected.
Absolutely. That bench can, no, it is not the regular bench is taken up, not the environmental bench is taken up this matter. This matter is taken up with a regular bench.
No, but if he is asserting his rights, constitutional right.
Constitutional right, definitely, Lordship, it can be looked into. But when I am saying, Lordship, on affidavit also we can place that we are not, what is his right? His right to worship his way of practice to worship.
So you respond to his claims.
Now, Lordship, my humble submission is that at this stage,
What is the stage of the work?
what is, final?
What is
We
the
have
stage
got
of the
comments to
work?
our information, nothing has been done.
Lot of permissions, Lordship, it is not going to start in a day. It will take years. Huh?
Then let
Now-
me say statement, then you can continue doing the pending.
No, no, why? My first question, my first objection is that the locus standi of this petitioner.
We'll take it up. Look at.
First, the maintainability of petition may be heard. So Lordship may issue a short notice to us
Okay.
only on the point of maintainability. Then the other issues can be opened up because all the other issues are opened up before the division bench. It is going on. It's a multiplicity of the cases.
Yes, okay.
In the meantime, they'll maintain status quo.
So Lordship, that order may not be passed.
Advocate General's assurance is
No,
going
no,
on.
things are going on. It is, the meetings are going on, the process for permissions are going on.
You proceed. You proceed.
No, no, the work is going on like this, Lordship. There is a playground. I'm saying, Lordship, there's a playground. We have to shift that playground to the downhill. So that playground area will also be a part of this corridor, which has nothing to, the games are.
That's the whole issue. The whole issue is while restructuring the portions of
The restructuring now, what we are going to.
whether there are areas or there are places which are a essential part of the process of worship.
These areas are used by public, not for,
But he has to decide on this, that it is excluded. This is the area out.
let them come with a particular specific environment, that a particular area which is a part of the main temple where practice and worshipping is going on, that part is affected.
No, but that should
That Lordship, they have to convince first.
It is my government that the entire Nilachal hill is sacred.
Yes,
Then-
that is his.
Then entire Nilachal hill is affected. Then what about the tourist guest house? What about the number of Blue Moon hotel is going on there?
No, that is okay. But
Where
what
are
we
the
saying
parking
is-
spaces?
What we are saying is.
What my friend is saying is a dangerous statement. It's a dangerous statement in my humble submission.
Inviting you to take action.
That will create problem for him also. That is not possible, Lordship, that is not contemplated.
No, we are only concerned.
Lordship's
the
concern is perfect, but when the chief secretary
sanctity
says,
of the
sanctity,
of
that's
the-
why I placed this affidavit of the chief secretary, which has been filed before this honorable
But
court.
before that, the authority must identify that area, that this is the area.
We have the map.
So place it before the court.
Then no interim order, I will place the map tomorrow. I have the map. It is not that clandestine, all this 5 long meetings.
You bring it by way of an affidavit so that they get an opportunity to respond.
Absolutely no difficulty, but number one, whether he in this writ petition can raise this question or not. It has public interest element.
Heard. We'll issue notice at this stage. Heard.
A short notice, that's correct.
Done it.
On the maintainability also.
And on the interim prayers.
Senior counsel appearing for the petitioners. Assistant Director. The petitioner claims to be a member of, is a resident,
Bor Pujari, Borderi.
is a resident of the Kamakhya Mandir complex. He's a resident within the Kamakhya Mandir vicinity and claims to be a member of the Bor Pujari or Bordeuri.
Both. The Supreme Court judgment actually uses Borderi, but they describe themselves as Bor Pujari. It's the same thing.
You are saying is synonymous.
Synonym. That's why I said both.
Is one of the member of the four. How many
Four
families
families.
are there? Four. Four Bordeuri / Bor Pujari families who are running the affairs of the temple and the Garbhagriha and the adjoining temples within the Kamakhya Mandir complex. So, the learned counsel for the petitioner submits that the religious practice of Tantra being worshipped in this, is being practiced and worshipped in the Kamakhya Mandir. And the same has been followed for more than, or near about 2000 years, as per the recorded history. So, the counsel for the petitioner has drawn attention to several academic and scholastic articles which were enclosed to the petition to show that the worship is not essentially of an idol, but of the water and the place in which is within the Garbhagriha of the temple, as well as within the adjoining temple situated in the Kamakhya Mandir complex. So, the petitioner claims that his rights under Article 25 and 26 of the Constitution are likely to be affected in view of the recent decision of the government to step up the work in the Kamakhya Mandir. What is that work?
Kamakhya corridor.
Kamakhya Mandir, Kamakhya
Access
complex,
corridor.
access corridor, Kamakhya temple complex access corridor. Stop. It is submitted that except for the what are covered under the ancient monuments?
31, page 92, my lords, except that 91, 92, or 30, 31, 32.
Except the
31, 30, 31. Dorgarila.
Dorgarila rock inscription and the rock cut figures and one stone gateway within the Kamakhya Mandir temple complex. None of the temples or idols are covered or protected under the ancient monuments sites by the government of India. Stop. It is submitted that a similar act is also there in the state of Assam, but no steps are taken by the government, appropriate department in the government to list Kamakhya Mandir temple complex within those protected monuments. Stop. The apprehension expressed by the writ petitioner is in the process of undertaking the developmental works in the Kamakhya Mandir temple, Kamakhya temple access corridor. There is a danger of affecting, or there is a danger of changing the nature and affecting the standard, affecting the practice of puja offered by the devotees, including the body units. Since none of these sacred temples and garbhagrihas and idols are protected under the Sacred Monuments Act. So, it is the apprehension that the proposed developmental works will affect the eternal springs which are found in many of the temples, including the Garbhagriha, from where perennial source of water is always found and is considered to be holy and precious for the devotees who offer their prayers in the temple. Stop. Referring to, where is the civil work you have referred to? Where is
192, I think.
180.
192, I think, is that detailed notice inviting this. 200, I think, 200, 200.
Referring to the
200.
detailed NIC, NIT.
It's at 192 and 200 is.
28/11/2023 submits that the civil work and close to the
It's at 200.
to the bid process reflects construction of.
This is regarding consultancy part, Lordship. The main work is not going to start soon. It's a
No,
consultancy work.
This is for the construction, right? Consultancy.
No, no, page 112, 106.
No, it
No,
is-
192.
190 is a continuation.
No, it is not. It is a separate construction, EPC. It is EPC.
Reflects construction of basement plus 4 floors in the proposed area. The learned counsel to the senior counsel for the petitioner finds that these, since the temple is spread out over the entire Nilachal hill, the proposed construction is likely to affect the existing places of worship by changing their nature and structure, and also affecting the eternal springs which are within the temple. Besides, the danger of vilification or destruction of many precious stones, inscriptions, and items. So, he therefore submits that since the temples are not protected under the ancient monument, temple and temple complex is not protected under the ancient monuments act, save and except for the page number. Can you point out to that page again?
92.
93.
93.
93.
31, 32 and 93.
Page number 93, 31 and 32.
Item numbers 31 and 30 and 31, I'm sorry.
30 and 31. There is no authority, specified statutory authority, which will determine if and whether any of these sacred idols and scriptures, rock sculptures and sculptures and other archaeological sites and monuments are being protected in the process of the development works carried out by the state. So he therefore submits that an urgent order is called for, issuing a direction to the government to restrain them from proceeding with the notice to proceed with the work, which was issued on 15/3/2024. Till such steps are taken by the government to include the temple and the temple complex within the purview of the Ancient Monuments Records and Act, Ancient Monuments and Archaeological Sites of 1958, and of Ligor in Assam Ancient Monuments and Records Act 1959. Learned Council, referring to the Assam Act 1959, submits that section 15 of the Act imposes responsibility on the government to ensure the protected monument maintained by the state government. So, what is the protected monument is defined under section 3 of the Act. Similarly, under the Act of 1959, Federal Act of 1959, the protected protected monument, protected area is defined under section 2 HA. And once an area is declared to be protected under this Act, under section 20 capital A, the area has to be declared prohibited area for carrying out public work and other works in the prohibited area. Stop. Senate Council for the petitioner therefore submits that the state government, having failed to carry out the mandate of these two acts, the ancient temple and the temple complex is not protected under these acts, and there is every danger of the temple being affected and the right of practice of the petitioner and other devotees affected because of failure to adhere to the standards prescribed under the Act. Learned Counsel for the petitioner has referred to the judgment of the Apex Court rendered in Riju Prasad Sharma and others, quoted in 2015 9 SCC, 461 to submit that the right to carry on the practice of worship is vested on the four families of the four deities, and this has been upheld by the apex court. And the stand of the state government in that respect has also been reflected in the state judgment. So he further refers to the judgment of the apex court in Commissioner of Police and others versus Acharya Jagdish Swarayananda Avaduta, reported in 2004-12 SCC 770. Paragraph 9.
Paragraph 9.
To submit that the protection guaranteed under Article 25 and 26 of the Constitution is not confined to matters of doctrine or belief, but extends to acts done in pursuance of religion, therefore contains the guarantee for rituals, observance, ceremonies, and modes of worship which are essential or an integral part of the religion. Learned Counsel, Senior Counsel for the petitioner also refers to the judgment of the apex court in Rajiv Mankotia versus so-and-so, reported in 97 10 SCC 441. To submit that the apex court in a given case, to submit that in a given case, the direction can always be issued to convert a particular site to be a historical site and give the adequate protection required to preserve that place under the statutes available in law. We therefore submit that the respondents be directed to place before the court the steps taken to protect the monuments, the idols, complex, and also as to how the practice of the worship, the rituals, and other connected activities are sought to be preserved by the respondent state. He submits that urgent orders are called for staying the notice, impugn notice, proceed with the work issued by the government of Assam. The private respondent numbers will know by the notice dated 15/3/2024. Per contra, Mr. Deputy Cycle and Senior Counsel and Advocate General for the State of Assam submits that the writ petition is not maintainable in its present form, as the petitioner has failed to project before the court his true and correct intention of challenging the impugned orders. He submits that a similar issue is pending before the division bench of this court in PIL number 12, where the department has already filed their affidavits. He has placed a copy of the affidavit before this court to submit the stand reflected by the state in the said affidavit. He submits that the state has assured that all steps will be taken to preserve the sanctity and the practice and the process of the religious worship carried on by the devotees, including the devotees. The only work which is being sought to be undertaken by the state is developmental work, making the sacred monument, for providing ease of access to the various devotees which come every year, the temple stop. He has submitted that there is no decision taken by the government at this stage to even alter any of the temple complexes or
No,
procedures.
from the very beginning, that decision is taken. That is why the consultancy service, page 112,
He submits that prior to issuance of the NIT and the notice to proceed, a consultancy service was called for, and it is after in-depth study of the entire
page 112,
practices and
Structures.
worship structures, ancient structures which are prevalent there, that the state has decided to carefully chalk out a plan for carrying out the development activities. So,
under a central scheme,
under a
PM
central
Divine.
scheme, which is PM hyphen Divine,
Divine.
DIN.
And there is a direction of the Supreme Court to implement that also.
He submits that in which manner?
I have placed the judgment, no?
Okay.
In the affidavit, we have placed it. There is a direction that will
He
through
has
letter and
referred-
spirit, we have to
he has-
comply that.
He is referred to an order of the apex court dated tenth of November 2023, passed in civil appeal number so and so, diary number so and so, Kabindra Prasad Sharma versus Chief Secretary Government of Assam, wherein the stand reflected by the state government is that they will strictly abide by the procedure prescribed and the standards prescribed under the PM Divine scheme.
Lordship, one more moment. Two small paragraphs of that affidavit that will clarify further.
And the apex court, having taken note of such averments made, has directed, has recorded the averments made, and has directed that the state government shall abide by those assurances presented in the form of affidavit in its true letter and spirit.
Paragraph 16 and 18, very short paragraph. Paragraph 16, we said, the deponent denies that the construction of the project work would have any impact on the method of worship and overall sacredness and uniqueness of Ma Kamakhya temple. That is number one. Paragraph 16, I have not got it.
That's the whole crux of the matter.
That is why
whether he's on what basis has he made this statement?
we have the basis.
No.
If
so
Lordship
that-
wants
that-
elaboration, we'll elaborate.
No.
That is why when we
find
filed
out.
this affidavit,
Uh.
the other side took 3 weeks time to give a response. The case is at that stage.
Right.
And 18, paragraph
No,
18.
we are not even doubting.
Now
your
18, Lordship,
statement.
may I complete 18? Then Lordship.
Yes.
As regard the statements made in so and so, there is no comment. However, the deponent begs to state that Ma Kamakhya temple is not a declared archaeological site under the act and the rule. However, the project in question have been undertaken by the respondent without touching any of the temples in and around Ma Kamakhya temple. So that also clarifies his position.
Mr. Learned Advocate General has also referred to the averments made in the affidavit filed in PIL number 12/2024 in para 16 and 18 to submit that the state has made a categorical averment that the project work will not impact the method of worship and overall sacredness and uniqueness of the holy deity. And the project work in question has been undertaken by the responsible department without touching any of the temples in and around the temple complex.
And paragraph 19, Lordship, one more. That 100 meters issue is also dealt with. That in paragraph 39 of the petitioner, deponent denies.
He further refers to para 19 of the said affidavit to submit that the area up to 100 meters radius from where?
May I read it, Lordship? The petitioner, that the deponent denies that the Ma Kamakhya complex area has been declared as protected under the 1958 Act, and the area of up to 100 meters radius has been declared as prohibited area. Because in Ma Kamakhya temple also, within 10 meters, there are a lot of complexes, residential complexes, those we are going to remove now. The deponent says that the area where the project of Ma Kamakhya access corridor is to be executed is presently marked by unplanned residential and commercial buildings, which restricts free access to the temple and negatively impacts its visual character. The work has been proposed with the aim for creating public open spaces, pilgrim amenities and facilities, and all-weather access corridor for pilgrims along the periphery, including the free access to the elderly and differently able persons to the shrines. The project in question has not intervened with any of the temple shrines as it exists. So categorical we are here.
No, but you have said 100 areas, 100 meters radius to be declared prohibited.
We are denying because at present within 100 meters, not only the commercial, there are residential complexes are there, hotels are there. We are going to remove everything. We are clearing. That is why we doubt the intensity of this petition also. The motive behind
The
this.
learned AG therefore submits that when the proposed work was conducted by after due publicity and detailed meetings and conferences held with the representatives of the board, Deori Samaj and other government officials along with the state administration at the highest level. However, no such objection at the relevant point in time was raised.
Your lordship may record, I dispute that because no consultation was carried out with us.
He therefore submits that the intention of the present writ petitioner in filing the writ petition challenging the impugned orders does not appear to be bona fide. Learned senior counsel appearing for the petitioner, Mr. U. Hazarika, learned senior counsel appearing for the petitioner, however, disputes the submission made by the learned AG to say that insofar as the writ petitioner or his family, only the writ
And
petitioner,
other similarly situated.
he disputes the contention that any consultative steps were taken with the board duties, including the writ petition. Stop. Considering the rival submissions made in the present writ petition, and also upon careful perusal of the pleadings available on record and the judgment cited at the bar, this court is of the view that the matter will require
at this stage, notice may be issued only to the state of Assam. Lordship will respond whatever we have to
require adjudication. Therefore, let notice be issued.
In the PIL also, only the state government was issued notice.
Be issued to the state of Assam, all right, will issue state of Assam and PWD.
One of the Archaeological Survey of India, because the parties coming under the PM Divine scheme.
Lordship, later on, if Lordship is not convinced, if
this is the
Lordship is not,
central
let me complete. If Lordship is not convinced with the state government's affidavit, Lordship may issue notice to all. But let us first give the
How
response.
does it affect?
How does it?
No, because this will delay the whole case. Because in all the PM Divine meetings, Archaeological Society, Ministry of Forest and Environment, everybody was party. It is not an archaeological site.
All the more reason they should be represented.
All are parties.
Let notice be issued. So we'll issue notice to all, let notices be issued.
Lordship, my humble submission, first the maintainability point.
We'll keep
The
it open.
preliminary queries which has raised before this honorable court.
We'll keep it open. We are keeping the maintainability.
No interim order may be passed. That is my only submission.
The notice be issued to the respondents. Returnable 2 weeks. Who's for the CGC? Anyone for CGC? Let the Mr. R.K. Dev Chaudhary, learned DSGI, represent the respondent number 1, 2, 3. Stop. Mr. D. Nath, Senior Government Advocate, accept notice on behalf of respondent number 5.
5 to 9.
5 to 9. Stop. Steps be taken on respondents 4 and 10 by usual course and registered post AD within the course of this week. Extra copies to the respective councils be furnished within the course of the week. So the respondents are at liberty to file their counter affidavit if so advised, stop. Since the question of maintainability has been raised before this court by the respondent, let the matter be listed again on, give us a date.
Let it be on 3rd of June.
Yeah, it should 2 weeks, so we'll have it on 7th.
Because it from 4 till 13th, I'm not available.
Do I live in Delhi, but I'll be in Assam, my lord. My learned friend's schedule has to be adjusted.
So
I don't know.
let it be on then 18th of June.
18th.
18th, I think is a bit late. Can it be on?
Third, I'm ready for earlier one. No problem. 1 week's time may be enough.
Why? Returnable on 3rd. 3rd of
My learned friend's schedule.
issue notice on the interim prayer also.
I'm ready.
Returnable on the same day. Question of grant of interim orders will be considered upon, will be considered on the next day.
Great.
Lots. And maintainable point is also kept.
We'll keep it.
Of course, your point. I'm grateful.
Yes, yes.
Matter relates to disqualification of elected member of board of directors of cooperative society. And this petition is prepared only on law point laws. And official respondents have filed their affidavit also lost. Impugn order at page 73 lost.
Yes.
Page 73 lost. By this impugn order lordship, petitioner was disqualified and his nomination was declared to be invalid lordship by the Register of Cooperative Societies. On a petition filed after expiry of 3 days, which is mandatory as per rule to prepare the election petition within 3 days lordship. And there is no provision to condemn the delay lordship. That is the law part. And another aspect is that the lordship, this election was challenged by 2 elected board of directors were also elected along with the petitioner lordship.
Okay, now
Then, while issuing
there is some interim order.
interim order is afforded.
Yes. Now, you have filed your response.
Yes, Your Lordship.
Then,
Otherwise, Your Lordship, the issue is that the complaint petition that has been filed
Hmm.
by the respondents, Your Lordship, that has been filed after 3 days limitation period, after the limitation period is over, Your Lordship. And that apart, now, Your Lordship, the elections were already held. Now, the board is on the urge of constituting the board of directors meeting, Your Lordship. AGM was held, election results were
complaint
declared.
petitions filed by whom? By members?
Elected, 2 elected, another shareholder. 2
Another
elected.
shareholder.
Any election dispute as per rule, lordship should be raised within 3 days. Election rule. But it
Election
was-
rule 27, Your Lordship, 2019 rules. They need to file the complaint within 3 days, but here
The
in this
election
case,
was held on 27/8.
it was held on 27/8 and results were declared on 29/8, Your Lordship.
29, so 3 days.
3 days, but it has
So
been
there'll be
filed
30, 31 first.
first. Now, here in this case, they have filed the complaint petitions on 13/9/2023.
So who's for the respondent?
I'm for the reference number 10 and 11.
What do you submit?
Illegalities cannot be known by provision of rule. Lord.
Why? You have to file it within the time frame. Otherwise, it becomes final.
Lordship, respondent number filed the petition before the registry after 3 days later. Lordship.
You satisfy us that in spite of that, the authority can hear this issue, notwithstanding the limitations specified under the statute. Yes,
Lordship, one week time maybe given Lordship.
1 week time.
And Lordship, Honorable Apex Court also let them that full bench of the Apex Court in cooperative society election, Lordship, in respect of Kerala, I have annexed the judgment also, Lordship. Page 81 is the judgment, Lordship. Page 81, Lordship. I have annexed the judgment, full bench judgment. Cooperative part is page 91, paragraph 11, Lordship.
Yes.
Page 91 of cooperative part, paragraph 11, Lordship. May I read, Lordship?
Yes.
Section 69 of the Act is the mechanism provided by the state legislature as contemplated under Article 243 ZK2 of the Constitution of India. Once the mechanism provided under the statute provides for a time schedule for preparing an election petition, in the absence of a provision in the statute for enlarging the time under any given circumstances, no court, whether the High Court under Article 226 or this court under Article 32, 136 or 142 of the Constitution can extend the period in election matters. In the matter of limitation in election cases, the court has to adopt strict interpretation of the provision. This court in so-and-so, though in a different context, has held that at paragraph 33 that in the absence of any provision made in the Act for condoning the delay in filing the election petition, the Chief Justice has no power to condone the delay in filing the election petition beyond the period of limitation prescribed in law. Lordship, I have quoted Rule 27, Lordship, I have quoted. Page 19 of my petition, I have quoted this election rule, Lordship. Rule 27, Lordship. Of the Assam Cooperative Societies election rule, same under the Act, Lordship. Page
No,
19.
on the basis of the complaint petition, your nomination, your election was interfered with.
Election, yes. Nomination was declared to be invalid.
Nomination.
After declaration of result. After declaration.
What is the stand of the state?
They have filed it.
What have you stated?
Very good.
You filed an affidavit.
Yes, Your Lordship.
Where?
Also page 111, running page there. Paragraph 3, Lordship.
3, Your Lordship.
Paragraph 3.
There is no affidavit here. When did you file it?
Lordship, I have filed it on
Heard learned counsel for the parties, the counsel for the respondent, Mr. Lipotoloi submits that an affidavit has been filed on
1/5, Your Lordship.
1/5/24.
Lord.
However, the same is not available in the case report. You have been served copies.
Yes, Lordship. I have.
Stop. Registry is therefore directed to trace out the affidavit stated to have been filed by the respondent cooperative department and connect it to the case record. Matter will be listed after 2 weeks.
Interim method.
Interim order passed earlier will continue. Yes.
Lordship, for the
You have
last
taken
of the-
steps.
Yes, my Lordship.
You have taken steps.
Yes, my Lordship. Notice may go, my Lordship. I have submitted amended post title also.
Who are the new parties?
My Lordship, the newly implemented contemner is my Lordship.
Respondent 4.
Yes, my Lord. Commissioner and Special Secretary to the Government of Assam, Department of PWD, Building and National Highway. He is the authority, my Lordship. Sri Raj.
ইয়াত দিম ভোট দিলে কেনেকে আমি এনক্ৰ'চমেণ্ট কৰি পেলাই ইয়াত দি দিব ছেকশ্যন নহয় joint register. In pursuance to the directions of this court by order dated 6/5/2024 in IA number 1270 of 2024, the petitioner has filed, as permitted, the petitioner filed the amended post title showing the newly impleted respondents. Accordingly, let notice be issued on newly impleted respondent number 4. Mr. R. for appears for.
My lord, I am preparing for respondent number one, though valid. We have filed an affidavit. This man has retired from 1.5 years. So new incumbent has already taken over, my lord. If subsequent anything is to be done, my lord, then he is no more in the office, my lord.
Anyway, you are appearing for respondent 1.
One, my lord. He has
Appears for
already
respondent 1. He, however, submits that the impleted respondent number 4 has, to the best of his information, has also retired from office.
Respondent number one has already.
Respondent number 1. Respondent 1. I'm talking about 4.
No,
Four is there. He has appeared on behalf of respondent 1, who he submits as, in the meantime, demitted office. So, the petitioner may take steps, necessary steps, if so advised, in respect of respondent number 1. Let notice issue on respondent 4, returnable 4 weeks. Steps on respondent 4 by usual course and registered post 18 trustees also. It start to 4 weeks.
Your lordship. Service is complete, your lordship.
Service complete.
Service complete. Affidavit on justice officers filed by 16/2, your lordship.
Service on
Service on 6/2, then it. Lesson number 6 and 7 appear and file affidavit opposition, your lordship. I want 2 weeks time to file counter.
respondent 6 and 7 has filed an affidavit, learned counsel for the petitioner submits that she would like to file a rejoinder. He prays for 2 weeks by the time. It is also submitted that steps on respondent 8, 9 and 10 has also been effected by justice service and an affidavit to that effect has been also filed. However, none appears for respondent number 8, 9 and 10. You're appearing?
No, look, I'm appearing for KAC. Respondent number
Mr.
2 to 5.
Ronghang appears for respondent 2 and 5.
2 to 5.
2 and 5. 2 to 5. Mr. So-and-so, Mr. H. Das appears for respondent number 6 and 7. Matter be listed after 3 weeks.
Lordship, respondent is yet to file your affidavit.
Who is the respondent? Mr. C. Sharma, learned standing counsel appearing for Water Resources Department, prays for appearing on behalf of the standing counsel. Prays for 3 weeks time to file necessary affidavit. You are appearing? Learned counsel appears for respondent number 8. Matter stands deferred for 3 weeks, enabling the respondent to file the affidavit. So and so it is for the.
That is your lordship. Lordship, kindly pay rules order dated 3/5/24, lordship.
3/5?
24, lordship, Lawazima order.
Okay, that. So notice not served on respondent 4.
4, lordship. I'm praying for paper publication.
Who is respondent 4?
Sri Jhulan Das, lordship.
Who is respondent for?
Lordship,
Why is he a respondent?
Lordship, he is the projected buyer of the property of the petitioner, Lordship.
But if he has left that area,
Lordship.
where is the guarantee that he is still within the state or the town?
Lordship,
Then paper publication. You are aggrieved by what? You are aggrieved by?
Lordship, he filed a suit before the,
So what is the stage of the suit? Is it still alive?
Lordship, I have to take instruction.
Take instructions. If he is pursuing the suit, then he is here. He may have changed his
Lordship.
address.
Lordship.
Yes, Mr. Dotto?
Your Lordship, I am appearing for respondent number 1, Silchar Municipal Court.
Are you also, you must be also party to the suit.
Yes, Your Lordship.
Then?
Your Lordship, what happened, respondent number 4 has filed a complaint against the petitioner. That is why we have asked an order dated 2022, where the sale permission was being taken away from the petitioner. And that's
Cancelled.
why, yes, Your
You've
Lordship.
cancelled it.
Yes, Your Lordship. That is why they have filed this petition to quash the order.
So that is okay. The matter is at the stage of service of notice on respondent 4. It is notices are returned saying that he is no longer there in the address. Now, if the suit is being filed by the respondent 4 and it is still alive and pursued,
Yes.
then he's obviously there. You get the, you give the address, we'll issue a direction. You obtain the instruction.
Lordship.
Then a counsel for the petitioner will obtain instruction, seeks time to obtain instructions as to whether the civil suit filed by respondent number 4 is still being pursued. The status of the civil suit stated to have been filed by the respondent number 4, so as to ascertain his correct address. Mr. S. Dotto appears for respondent 1.
1.
Let the matter be listed after 4 weeks.
Much obliged.
May please the law. Non-compliance of order, Your Lordship. 19/7/2023. To find page 11, Your Lordship.
Yes.
The last 8 number paragraph, Your Lordship. As the petitioner has already produced a copy of next and kin certificate, it would be open to the office of the Deputy Commissioner Goalpara to cause an appropriate inquiry and to release ex gratia relief to the petitioner within period of 60 days from the date of receipt and certificate of this order. And thereafter, Your Lordship kindly see page number 12. Within the 60 days, Your Lordship. Page number 12. This is the representation submitted by the petitioner along with order, Your Lordship.
You read the last lines of para 7, just above para 8.
Para 8, Your Lordship.
Above para 8.
The petitioner shall produce a certified copy of this order.
No, no, no.
Lordship.
End of para 7.
7.
End, towards the end of para 7.
Lordship.
Page number 11. The court is inclined. Have you found it? Second line. Para 11, page 11.
Page 11. The court is inclined to direct the Deputy Commissioner Goalpara or any subordinate authority authorized by him to visit the house of the petitioner to collect such information. However, at the at this stage, when the petitioner has been waiting for adequacy amount, it would not be open to the authorities to ask the petitioner to submit any document. Rather, they would have to visit the house of the.
So where is has the inquiry been conducted?
That part, the learned will
No,
say.
you have filed a representation. before
Representation
the
along with
commission.
order. Along with order, your lordship.
Commissioner is not directed, it is the DC who is directed.
Yes, lordship. And also, this is the receipt copy by the DC, your lordship. That you seen. Page
you
number
have-
12,
you have-
last.
You have addressed it to the commissioner,
Yes,
not
wrong,
to the DC.
wrongly recorded, your lordship, petitioner. And wrongly.
Yes, who's for the DC?
I am appearing, my lord.
But
What is the status of the inquiry?
Yes, my lord, it is pending at the status of, my lord, the information, my lord, with regard to next of kin of the deceased person. And
Already-
verification exercise is going on, my lord.
Already-
I have received the instructions, my lord, on 1st of May 2024, my lord. It says, my lord, that the inquiry is going on. Now it is only at the stage of, my lord, receipt from the NOK as well as police report. And the.
This is an order of 19/7/23.
Yes, my lord.
So what inquiry are you carrying on?
Yes.
Court has kindly see the para 3.
Yes, my lord.
He is submitted next of kin.
Already submitted.
So in the district, have any doubt in this regard from so and so, court is inclined to direct the deputy commissioner to visit his house and collect information. So does it require, it's going to be 1 year now.
Okay. Perhaps, my lord, due to election process in between, my lord, some delay has been called. Lordship will kindly allow me some time.
Election has started this year. This order was passed in July
Yes,
2020.
Yes, correct.
19/7/2020.
You get instructions. Why is the DC sitting over it?
Page number 13, your lordship, bottom part. The petitioner submitted copy of next and his certificate along with relevant documents, your lordship. Page
So,
number
Mr.
13.
Counsel, the direction is issued to the DC and you are filing a representation to the commissioner.
Lordship, but wrongly filed, your
So
lordship.
wrongly filed, why have you not corrected it?
Page number 12, your lordship. Actually submitted to the DC, your lordship. That still is reflected, your lordship. Page number 12, bottom part.
If he has submitted, he has accepted perhaps and send it to the officer, the commissioner's office. Alternate counsel for the parties,
My
Mr.
lord.
R. Porpujari appearing for
My lord, the respondent number 2, that is the DC.
respondent number 2. We'll obtain instructions as to the status of the inquiries, as to why the directions of this court has not been complied with. Directions of this court by order dated 19/7/2023 passed in WPC number so and so has not been complied with by the DC. Let this information be placed before the court by the next date fixed. Let the matter be listed again on 19th June.
Obliged.
I'm obliged.
Will kindly see the last order passed by this court. 34/2021. I'll just tell your lordship why we have approved this honorable court. And I will show the orders. My lord, there was an SOP issued by the state government on 27th of December 2023 regarding about the traditional fight, Mojus and Bulbuli fight. They've issued an SOP saying for Mojus, a particular period has been mentioned, 15th of January till 25th of January. Apart from that day, you cannot hold any Mojus. Bulbuli fight also specified date was given. Now we put to challenge before this court and said, this is absolutely violation of the statute. 1. Number 2 is a violation of the order passed by the Supreme Court. You cannot hold, this SOP will also not stand. In view of the judgment, A. Nagaraj, that judgment has been clear, categorically has been stated. You cannot hold because the violation of the statute. Now, my lord, the matter, even it was 27th of December, we came later on. 1st of February 2024, there was an order passed by the court. They said, SOP says that this is the period. Now we projected, even the period which you have mentioned, beyond that, some of the district is holding. How can you do it? Now the court said, no, you can't do it. So there was some direction which was passed by this honorable court. On first, on fourth, on sixth, various direction, and 3 additional affidavits were filed before this court, projecting it, even in spite of the court's order, they are violating, and all the district administration also are not looking into it. The specific direction was given. Last, my lord, direction which is passed, kindly see on 34/2024. The petitioner has filed an additional affidavit bringing on record the instance of buffalo fight is allowed to be taken by the by the authority of say in violation of the order of the court as well as the Honorable Supreme Court. Whereas such buffalo fight has been clearly banned, heat of prevention of cruelty of animal act 1960 and Wildlife Protection Act. The fundamental challenge writ petition in the SOP guideline prepared on the basis of decision of the state cabinet on the ground. Same are in contravention of law made by Parliament as well as judgment of the Honorable Supreme Court. The court-wide order dated 6/2024 taking into consideration the entire matter and the judgment of the Honorable Supreme Court observed pendency of writ petition, the state government shall ensure strict compliance of notification SOP set of guidelines in respect of buffalo fight modules. It has been observed if any information regarding holding of buffalo fight in violation of the aforesaid notification etc. is received, petitioner has granted liberty to bring on record or notice of this court. Thereafter, on 9/4/2024, having consulted additional affidavit filed by the petitioner, wherein instances of buffalo fight have been allowed or organized in the district of Nagaon and Morigaon, this court took a serious exception and observed that prima facie there is a violation of the order of this court dated 6/2024. However, it has been observed that before passing any adverse order, state government is granted an opportunity to address the same within 2 weeks. So and so, a learned counsel submitted except for the period allowed by this court by the interim order. State government has no knowledge about other instances of organizing buffalo fight. This court finds it hard to accept the submission of the learned state council, inasmuch as not only today, on the last 2 occasions, the petitioner could bring on record the instance of such buffalo fight in the state. It appears the state authorities are not taking the matter seriously, which this court takes a serious exception to the same. However, since the learned so and so prays for time to address the issue by filing affidavit, response to 2 additional affidavit filed with the petitioner, in the interest of 2 weeks time is granted. It is made clear on the next date, no affidavit response is filed, appropriate orders shall be passed. In the meantime, it is that state government should ensure that no buffalo fight is ordered in the entire state of Assam. So this is the position. Now they have to inform the court whether any steps were taken, because it was repeatedly those applications were filed before the court, additional affidavit. Specific, my lord, we brought notice to the court, the fights which were still going on. So court took a very serious view, my lord. Now, what is there, my lord? Affidavit has to be filed in the main case. Till today, no affidavit has been filed.
No, this is an IA.
Yes.
IA for what?
Man, IA, there is,
Restraint.
yes. Not only, there are 3 IAs were filed. Different IAs were filed because the court, initially when the court has taken on the matter, court said whenever there is a fight, it is brought notice to you, then we have been given liberty to bring it by way of an affidavit before the court. So from the very beginning, this is a 3rd affidavit which has been filed before the court. So this is response has to be given by the state government.
I have got the instruction from the Morigaon because the specific allegations were released apart from the other. There is no such fight for that after 65 days.
You bring it by way of an affidavit. Bring it on record.
That is from the SP Morigaon.
You bring it on record.
This is what I have not seen. This is what my learned friend is saying, that after the specific order passed by the court, there is no fight thereafter. But what we brought notice to the court, even in spite of the court's order number 1, first from the very beginning, there are fights which we have brought by additional affidavit. So my learned friend has to give a reply why those fights are being held, even in spite of the court's order.
That's what,
This
that's what.
this says that there was a
There's no fight. And
organized, there
if
was
that is so,
a particular instance where it was organized, but
organized.
it was prevented.
Very well, very well. Well, if that be the case, let them bring an additional affidavit by affidavit. We'll give a reply that even there was a flight because the authority concerned has received it. They have received
Received what?
FIR. We have filed an FIR before the authority concerned. We have filed an FIR.
All right. Third, Mr. D. Das, Learned Senior Counsel, assisted by Mr. D. Das. DJ Das. And Mr. PJ Talukdar, Learned Senior Counsel, assisted by MS.
My lord,
P.
my lord, my learned friend come from Delhi. Her name should be reflected.
MS. A. Kedia. Also Ms. A. Kedia. The grievance of the petitioner is that notwithstanding the prohibition under the Statute of Prevention of Cruelty to Animals Act 1960 and the Wildlife Protection Act 1972 and the Ketanau judgments rendered by the apex court as well as by this court, the buffalo fights and the bulbuli bird fights are being organized by various committees and submittees at village and district level. Stop. These have been brought to the notice of the district authorities. However, the district authorities have failed to take any step for prevention of these fights. Some instances have been referred to by the learned counsel to the petitioner. In view of the fact that no such steps have been taken to prevent these fights, and this particular IA has been filed praying for interim orders. This court by order dated 3004/2024 had directed the respondents to file their affidavits, and in the meantime directed the state government shall not ensure any buffalo fight is organized in the entire state. So it is seen that this is an IA praying for orders under section 1 and orders to restrain the state from conducting any bulbuli fights, as well as only bulbuli or buffalo.
Buffalo, my lord.
Your IA is
We have only bulbuli.
Bulbuli fights.
Buffalo in the main writ petition. There, because the buffalo fight was, the court was in.
And therefore, appropriate orders have been prayed for under Article 26, read with Section 151 of the CPC. So, accordingly, let notice be issued. Notice has not been issued here.
My lord, they are, they already.
Right, so we'll issue notice.
Already appeared.
Notice has been issued, returnable 3 weeks. 3 weeks since
In respect of IAs.
MS, yeah, in the IA. MS so and so assisting Mr. PJ Talukdar accepts notice on behalf of 1 and 2. Steps on respondent number 3. Opposite party number 3 by usual force and registered force CP. Stop. Where Mr. PJ Talukdar has placed before the court a communication dated 2005/2024 from the SP Morigaon district, which states that no buffalo fight has taken place in the district. Stop. The said communication reflects that although on 13th, 14th and 17th of April 2024, the committee under the Morigaon police station had planned to organize the buffalo within quotes Mohjus fight, but the district police prevented the event from taking place. Stop. Since notice has been issued, let the state respond to the contentions raised in the IA. In the writ petition, have you filed any?
My lord, that's why I'm saying, I just want to just place it. Writ petition as on date, number of times is given, they have not filed. So if we fail to file,
on a next date, in the main writ petition, we have asked for stay of the entire SOP. That interim order should be
Right,
granted.
that them respond in the IA as well as in the connected writ petition, if so advised. Meanwhile, the interim order passed earlier on 3004/2024. We also will continue. So let the IA along with the writ petition be listed on 21st June.
21st June. 21st June.
Subject to your availability in the country.
Ability I am there in the country. My lord, only one request, my lord. My objections will be recorded so far as those dates which it has been not been hold. We are saying that it has been hold. Now that's objection. That objection. may be-
Senior counsel, however, objected to the submissions made by the counsel to the respondent that this information, not a correct information.
Yes.
And to that extent, the petitioners had had placed, had lodged complaints and FIRs before the appropriate authority in respect of such illegal activity, which according to them had taken place, notwithstanding the statement.
I'm deeply of that.
Yes, you can take back the instructions.
I'm deeply of that.
His Lordship. Lordship, if I may please point out,
yes,
there is a IA filed by the bank, and the writ petition was filed by me, who is the borrower, Lordship. The respondent number 3 was the guarantor. He had earlier filed a writ petition, which is also pending before this court, Lordship. So if this petition is tagged with that petition, an attempt can be made to dispose of all the petitions together, Lordship, whenever it may be convenient.
But he has filed an IA.
Yes, sir.
Notice here.
Your Lordship, a small mistake has been done on the last occasion when we are submitting in the court, Your Lordship. That we have submitted that all the properties has been sold, whereas we are intent to submit that only the petitioner's property has been sold.
Lordship, notice can be issued in the IA.
No, in the IA, there is no order passed. Yeah.
No.
So we are issuing notice in the IA.
Lordship.
It's filed by the bank.
Yes, sir.
Seeking vacation of the earlier order.
Not vacation, Your Lordship.
Then?
It's only an
Modification.
Your Lordship.
Lordship, actually,
Your
what
Lordship, may
happened
kindly
is,
come to page number 11, the second last paragraph. The order was passed.
Yes.
Thereby, in the second last paragraph, Mr. C. Agarwal, learned counsel, however, submits on instruction that the projection made by the petitioner may not be correct, as all the mortgage properties in questions have in the meantime been attached and whereas it was intended to make that only the petitioner's property was sold. Only to that extent we required incorrect.
Basically, Lordship, my petition is that I am the borrower. I offered some property as collateral to the bank. The respondent number 3 as guarantor also offered one property as collateral to the bank. So after selling off my property in auction, leaving out the mortgage property of the guarantor, the bank proceeded to take one property which was not given in mortgage. So against that action, I have preferred this writ petition, Lordship. So when I made this submission before the Honorable Court, the bank comes and says that no, all properties we have auctioned and sold off.
Therefore, he now wants to correct it.
Yes, so Lordship, notice may be issued and the cases may be taken up together, tagged with Lordship WPC
He's
number.
only filing for correction of this. Are you denying this?
No,
This
I
is
am not
in
denying this, Lordship, but it can be taken up together and
what purpose? We'll dispose of the IA. He has made a statement that except for the writ petitioner's property, no, the others have not been attached and sold.
by that statement, I was deprived from an interim order that day, Lordship.
Huh?
From that statement
No, Your
itself,
Lordship.
I was
In regard to the
deprived from an
interim order-
interim order that day, Lordship.
Your Lordship, in regard to. the
Lordship may allow it.
You file an IA if you feel like.
Lordship may allow it.
Heard learned counsel for the parties. This IA has been filed by the Union Bank, submitting that the statement made by the counsel to the bank before the court on 22/11/2023 was inadvertently an incorrect statement, and therefore the same is required to be corrected. Stop. in the earlier order dated 22/11/2023, the following the following order was passed. You extract this order 10 and 11. Para. The learned counsel for the bank submits that in the penultimate paragraph, the court recorded counsel of the bank's submission that the projection made by the petitioner may not be correct, as all the mortgage properties in question have in the meantime been attached and sold. So it is within quotes and italics. Para. Learned counsel for the bank submits that this statement on fact was this statement was is not a correct statement, and the same was made inadvertently, and on the basis of because of some conflict of instructions, which because was inadvertently made, as the instructions received by the council were to the where appears to be incorrect. So he therefore submits that his IA has been filed. To so I think Mr. Saraf is correct. Why should we entertain this IA now? It's an interlocutory order. We'll correct it on the next day.
It can be disposed of, Lordship, on the next day.
Huh?
Yes, maybe you're.
Can we cut
Because
pending,
in
Lordship?
this main case, there is only challenge that the recovery officer's order was challenged.
The case needs to be tagged with, Lordship, WPC number 496118.
Do it. Same thing you write in the main writ. Main writ. Mr. Sharma submits that the statement has been wrongly, was inadvertently made. Therefore, he submits that the position on record is that only the properties of the writ petitioner have been attached and sold. Other properties have not been sold. Mr. Saraf, the petitioner, does not dispute this position on record facts. Accordingly, the it is recorded on the basis of submissions made by the bank that only properties in respect of the writ petitioner has been mortgaged and have been attached and sold. Other properties have not been attached or sold. So this averment, as it is reflected in the earlier order dated 22/11/2023, stands corrected to the extent indicated above. It is para. Mr. Saraf submits that there is another writ petition which is pending, namely WPC
4961 2018. 4961
4961 of 2018. He submits that both his writ petition be listed together that they be made to disposal same the next day. Accordingly, let these writ petitions be listed.
Any day before 21/6, Lordship. 21/6.
You want it on 21/6.
Any day before 21. It
Before-
is listed in DRT on 21/6.
We listed on 90.
Lordship.
File respondents are permitted to file their affidavit. In the IA, you write, in view of the order passed today, IA stands dismissed.
Obliged, Lordship.
May I please, Lord? Is it IA for expunging the name of respondent number 7 and 8 from the array of respondents?
Respondent number?
Respondent number 7 and 8, Lord.
Yes, you are appearing for?
I'm appearing on behalf of Corporation Department.
Anyone else appearing on behalf of the other?
Lordship, as per the latest office note, steps has not been taken.
Steps not taken.
Not taken. So I pray Lordship in the main repetition, allow me 7 days time to take steps.
In WPC number 5538, the writ petition was filed by the petitioners where respondents 7 and 8, Namgata Didi, are arrayed as respondents. This court by order dated 22/9/2023 issued notice of motion. Stop. The petitioner has now filed an IA, saying IA number 13, has filed the instant IA, seeking a direction to delete the names of respondents 7 and 8 from the array of parties. MS so-and-so appears for the cooperation department. Since no objection is raised by the respondent, prayer in the IA is allowed. Names of respondents 7 and 8, namely so-and-so, are deleted from the array of respondents, the writ petition. Stop. The petitioner will file amended course title before the registry within a period of 1 week from today. Steps, if not taken on the remaining respondents, be also taken by the respondents within 1 week as per the directions of this court by the order dated 22/9/2020. IA accordingly allowed in this court of. Deeply obliged. Writ petition will be listed after 2 weeks.
Hello, there is some office note regarding jumping of the caveat. In this case, my lord, notice was issued on 10th of April.
Yes.
In fact, my lord, there is a long note. I have not gone through it. So far as, my lord, the
note is very clear. Note says that there is no order on 9/1/24. When the writ petition actually challenges the prayer is for setting aside of the order dated 9/1, page 26.
My lord.
But according to the office note, there is no order of the revenue board on 9/1. It was passed on 29/1. And the caveat was filed by the private respondents seeking a hearing in respect of writ petition challenging the order dated 29/1. So therefore, when the writ petition was filed challenging the order 9/1, the caveat was not pointed out because there was no order. But the inquiry made by the registrar reveals that there is no order by the revenue board on 9/1. So there is a view of the registrar judicial which is also reflected in clause 10 in respect of the council. That the right of the caveators have been denied and made redundant.
Does it, my lord, mean that, my lord, the order has been manipulated? Yes.
We don't know. It appears to be so.
But this is
No, we don't know whether it is manipulated or not. It says that 9/1/24 there was no order. Where is the impugned order here?
At page 116.
116.
I'm giving a certified copy of the order sheet. It's a forged order, Milord. In the court's record, it's forged.
This should come by one affidavit, my lord, so that we can also respond.
No, how the registry will, it's there in the office note. Office note has reflected this.
My lord, this is the order at page 116.
116.
Yes, and for page 117 shows, my lord, 91.
No, I think there was some, you see, this is a copy,
Yes.
photocopy.
Yes,
So perhaps while photocopying, this two got deleted, because if you look into the order, continue the order at page 121.
Yes.
It is signed on 29/1.
Yes, yes.
The entire pleadings, it says 9-1. The entire petition, they written 9-1.
Junior must have gone by this order, but then how does it make any difference? I understand why.
No. They had filed a caveat.
Yes.
So the registry is required to connect the caveat the moment
And
the
why it has
petition
not
is
been
filed.
paid. But in any case, my lord, they are not prejudiced. No, nothing, no interim order is there, my lord. Only notice has been issued.
Okay.
I'll only submit very shortly. The office note, it pertains to an
We are
application.
not issuing any interim orders.
Yes, Milord. There's none.
So
But
we
I'll-
are, we are recording your presence.
Yes, Milord. That may be recorded. Only one thing, Milord. Insofar as the office note is concerned. The office note only refers to my flag A application and says that my caveat has been done. My application is not for that, Milord. My application is for institution of criminal proceedings against the petitioner here and whosoever is concerned in your lordship's view ultimately, Milord. Because this case, Milord, it's not of my caveat being done merely. It's a case of records being fabricated before this honorable court. And it has been done intentionally and maliciously. Why I say this, Milord, with great humility. Throughout the pleadings, in the prayer, Milord, thrice they've written 9-1.
Yeah, because
had it been so, had it been the case that they were aware and they were not intentionally manipulating the records before this honorable court, in the pleadings, Milords, they would not have written that the order is of 9th of January. Milords, the Hazira, Milords, which was filed on the day of the hearing, Milords, we have a certified copy of that also, Milords. I'll just show that, Milords. The filing.
Who represented the present petitioners before the tribunal?
The filing council before this honorable court, Milords.
Sorry?
The filing council before this honorable court.
Who is the filing council? I'm there. So you are not aware when the order was passed. This order appears to have been.
But my lord, the one thing has come to my mind. He must have filed an application before the registrar. This has to come, my lord, to the court. If anything has been done with, my lord, any ill intention, this is the court, my lord, the high court, which will, my lord, pass an appropriate order. They approaching the, my lord, the registrar by filing an application behind our back and, my lord, putting motive to it. That is, my lord, something not palatable.
Milords, my duty was to bring
And
it
in
before
case,
the honorable
what is
court.
the prejudice caused to him? The
Milords.
notice has gone only, my lord. There is no interim order.
No, that's a different issue. But is the filing council is the
Maybe, my lord.
council-
He may have made a mistake. He has taken it as a
That's for
9, my
him
lord.
to say, why are you apologizing on his behalf?
No, I'm not apologizing, my lord. What I'm
It is
saying
for him to say that how this mistake happened. He's competent to make a statement.
True, my lord.
That statement
then,
has
my
not
lord,
come.
the complaint filing before the registrar is something, my lord. This is not acceptable. Maybe he has made a
Testing
mistake.
matters, in a matter of testing nature, they're bound to make allegations because nobody will take this mistake of a council who represented the party before the authority, fails to take note of the date when the order was passed.
Look at from another way, my lord. Has any mischief been caused, my lord? My
No,
lord.
mischief caused or not, we are not even going into that inquiry as of the moment. We are on the conduct of the council. If the council was present, it is the duty of the council who files to make all verifications. That's what the rule says. You know it better than anyone else.
That is true.
So the rules say that he is to take all responsibilities.
True.
Then has he accepted or owned up his responsibilities to say that, sorry, this is a mistake, this is what happened, that is what happened. Now I can understand that the council who appeared before the revenue board was somebody else. And then he could have said that, yes, this is the copy given to me, this somehow skipped my mind. He is the gentleman who appeared before the tribunal. Yes, Mr. Bora, what are you doing? What is your?
Drafting the petition, Lordship, I have actually overlooked the date, Lordship, that's why.
When did you file the writ petition? When was the writ petition filed?
5th of April, 5th
Huh?
of April 2024.
5th of April.
At 122. In my complaint pillars, the list of documents at page number 122.
This is unfair to the court. So your mayor saying sorry doesn't help. You have to explain now why you have filed a petition. Why this matter should not be referred to the bar council. How you as a council appearing before the board can file an order, can file a writ petition without making verifications here. You have undertaken the responsibilities. You have signed certifying it to be true. You have signed it to be certified to be true copy.
Yeah.
Then how can it be true copy if you are not verifying with the originals? What is this, Mr. Bora? Huh?
I'm sorry, Lord. I have overlooked actually. While drafting the
But for today, judge will record my appearance. However, Milord, insofar as the complaint is concerned, if I may, Milord, with great respect to my senior counsel, I cannot place the complaint before the honorable court, Milord. It has to come through the registry. That's the process. For a 195 complaint to go again, it will go through the registry if it goes to the learned magistrate, Milord. Which is why I filed. There is no, in fact, Milords, I very humbly say, in a situation of this sort,
you pursue your complaint before the registry. We are not
Milords,
stopping you from
their view is that the imprimatur of this honorable court is required to institute a complaint, Milords. That is what they had said. That the view has to come from the honorable court that there is an offence, and insofar as the offence is concerned, Milords, 466 IPC, Milords, is very clear. If there is a record of a tribunal or a court which is altered, Milords, which is fabricated before this honorable court or any honorable court before the country, Milords, that's an offence under 466 IPC. And Milords, these are mens rea offences. Milords. Therefore, even if, and the mens rea comes from 464 IPC, so dishonest alteration is enough, Milords. I do not have to prove before the court below also, the trial court, that it was fraudulent or some harm has been caused to me. This is dishonest alteration, and that is what my complaint was.
This is, where is the original copy? This is the original
Yes,
copy.
because I've given the certified copy of the order sheet.
No, of the order.
Yes, Milords. It's in the certified copy, Milords. But I've given the honorable court. This is the certified copy.
No, this is the certified copy obtained by you.
Yes, sir.
Right.
Yes, Milords. The entire order sheet is there. The last order, the final order is of 29th. There's another copy, Milords, I have.
But what is that copy? Where is that original copy? You have not enclosed to the writ petition.
We have closed, Lordship.
Where?
The photocopy has only photocopy is there.
Original copy.
How photocopy?
Original copy.
Original is not enclosed. No, in the writ petition you have not enclosed the original.
Photocopy of the certified copy.
Huh?
Photocopy of the certified copy, Lord.
How? What for have you obtained a certified copy if it is not to be enclosed to the court records?
That's in the affidavit, Milords will see the writ petition. This form is a matter of record. This paragraph 34. This form
What is the procedure? The certified copy is to be enclosed?
Yes, because
as per the rules?
Yes, as since it is from the against the order of the from Board of Revenue.
He has done, he has enclosed a photocopy of the certified copy. We are asking you whether the certified copy is to be
It is required.
It is required under the rules.
Yes.
And strangely, how the filing has allowed this writ petition to be passed. You are the doyen of the High Court rules himself. Itself.
My lord, I have taken the brief and I have argued the matter, my lord, I have read it. And my lord, only notice has been issued. And now, my lord, arguing the mens rea and my lord, dishonesty.
No,
before your
first let us
lordship-
understand how this, what is the mandate of the rules. The High Court rules to some. The High-
My lord, when it is against an order of the my lord, subordinate court, the certified copy has to be.
How the filing is allowed this. Give it to the
No, my lord, that is required, ma'am.
you point out the relevant books. Heard. Mr. M. K. Chaudhary, learned senior counsel appearing for the writ petitioner, assisted by Mr. M. K. Bora, learned advocate on record. Also heard Mr. S. A. Gautam, and appearing for the respondent caveator. Stop. Respondent number 6 caveator. The petition is directed against the order of the Revenue Board dated 29/1/2024, passed in case number 32A, is it?
RA review.
The RA within bracket K, within bracket close within bracket again bracket RVW/2023. Stop. The application filed by the applicant therein came to be rejected. Review petition filed came to be dismissed, against which the present writ petition has been filed by the review petitioner as the writ petitioner. This court on 10/4/2024 issued notice written by no interim order was granted. The caveator, on the other hand, upon becoming aware that the petitioner has filed a writ petition, and notwithstanding the caveat filed by the respondent by the caveator, the notice was not served on the caveator. Filed a complaint before the registry. ID. Is the complaint available here somewhere?
Likely.
Filed before the Registrar General on 10/5/2024. Stop. The complaint is based on the fact that the order of as per the certified copy available of the order of the Revenue Board, which is under challenge, the date of the order is reflected at 29/1/2024. Stop. However, the writ petition has been shown to be directed against an order passed in the same petition on 9/1/2024. The writ petition at various places refers to the order as 9/1/2024, including the prayer, where the prayer for setting aside and interfering with the order is made. So, the caveator in its complaint has placed a copy of the certified copy of the has placed a certified copy of the order passed to the Revenue Board, wherein the date is clearly reflected as 29/1/2024. And on that basis, it was submitted that the the whole purpose of uh, reflecting the impugned order to be 9/1/2024 was to bypass the caveat which has been filed by the petitioner and which is what had happened. So the complaint was placed before the referred to the registrar judicial, and the registrar judicial has passed the following order in the ordership, in the office note by order dated 17/5/2024. Extract this order. Parent. On the learned counsel appearing for the caveator made serious allegations against the writ petitioner as well as the counsel. Are you making statement? Are you making submissions against the counsel as well?
For my
Made serious allegations against the writ petitioner on the ground that this entire manipulation was done to prevent the respondent's 6 caveator to be put on notice earlier prior to the court issuing the notice. So, notwithstanding that the court did not issue any. So, have you
In
found
fact,
the-
my lord, I stand corrected for writ petition, my lord, the certified copy is not required, my lord, but in other cases, if it is a revision or an appeal, then my lord, certified copy. That is, your lordship will find that chapter 5, my chapter 5A.
All right. No, but this is not a writ petition
as such.
As such, this is a writ petition which challenges the order of the court below. So the original certified copy is necessary.
Should be there, my lord, but the rules are, my lord, not clear on that. It doesn't say that it has to be.
It shows the rules where the copy is necessary. It shows the rules. Upon careful consideration of the rival submissions and upon perusal of the order which is enclosed to the writ petition, impugned order to the writ petition, it is seen that the date of the order as reflected page 117 is 9/1/2024 on the left side of the margin, whereas on the penultimate page at page part of the order at page 121 of the continuous paging at 121 of the writ petition, the order is signed by the Assam Board of Revenue, Chairman of the Assam Board of Revenue on 29/1/2024. The certified copy of the said order placed before the court has is also also reflects that the order was actually passed on 29/1/2024. Under such circumstances, the registrar judicial is directed to cause an inquiry and give a report as to whether, under the rules of the Guwahati High Court, the certified copy in respect of challenges made by way of an appeal or a petition of subordinate uh, of the court's subordinate court's orders. Certified copies of the state order are required to be filed are required to be enclosed to the first copy of the petition's file. So the report be placed before the court with complete reference of the relevant rules by the next 8 days. Meanwhile, since the caveator has already entered appearance at this stage, the caveat stands discharged. The respondents Since notices are already issued, the respondents are at liberty to file their counter affidavit if so advised. Further orders, if required, will be passed upon such a report being placed before the court by the registry as directed. Placed after 2 weeks. You have to be careful, Mr.